everybody to the second hearing of the committee's 2024 review of the dust diseases scheme. My name is Greg Donnelly and I'm the chair of the committee. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past, present, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today, either coming into the Parliament or over the internet. My name is Greg Donnelly and I'm the chair of the committee, as I've explained. I ask everyone in the room straight up to please turn your mobile phones to silent or to turn them off. Parliamentary privilege applies to witnesses in relation to evidence they provide to the inquiry at the hearing today. However, it does not apply to what witnesses say outside of the hearing. And I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of the procedures. Now we have a formal part where we need to have you sworn or affirmed to give your evidence, so we'll deal with that now if we could. So starting from my left with Mr. Farquharson, could you please state your name, your position title, and swear either an oath or affirmation, whichever you prefer, the words of which are before you. So, okay. Mr. Farquharson.
Good morning. My name is Stuart Farquharson and I'm the Interim Chief Executive Officer of iCare. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And can I offer the same to Mr. Mandana?
Good morning, everyone. My name is Rohit Mandana and I'm the General Manager for Lifetime Care and Workers' Care. I solemnly, sincerely declare and affirm that I will well and truly interpret the evidence that will be given and do all other matters and things that are required to me.
Could you just pause for a moment? I think the card perhaps could be around the wrong way. Not your fault. We'll just double check that, please.
Oh, I think it looks like I've got the interpreter's
No, that's okay.
card over here,
not a problem. We'll get that. So either an oath or an affirmation, whichever you prefer. I'm not quite sure what you've now picked up. So
I've got an affirmation. So
is that okay?
Yes.
Okay.
I'm all good with the affirmation.
Thank you.
So I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Good. Thank you very much. Well, thank you both for coming along this morning. I think, if I'm not wrong, both of you have not appeared before this committee with the periodic reviews we do of the statutory schemes in the state. So you're most welcome.
Thank you.
This committee has as part of its ongoing responsibility, the review of the schemes on a rolling basis. And we've always appreciated the cooperation given to provide very senior witnesses from the respective organisations, and you're most welcome. I don't know if you've been told about whether these hearings are difficult or not so difficult exercises. We don't seek to make them difficult, but we've obviously got some questions we'd like to ask you. And the reports that come from this inquiry by this committee are always important in terms of their findings and recommendations to go back to government to provide them with some thinking and ideas and even particular thoughts about ways in which matters can be dealt with to improve and enhance the operation of respective schemes, in this case the dust diseases scheme in New South Wales. But can I commence by inviting an opening statement, and that might be a good way to get things going. So, Mr. Farquharson.
Thank you. Well, good morning, everyone, and thank you very much for the opportunity to be here today to discuss the dust diseases care scheme. iCare's role is to administer the scheme and arrange compensation when somebody is identified as having a compensable dust disease. And in accordance with the legislative framework, the scheme covers financial assistance for workers, loss of income, and reasonable medical expenses for treatments and care related to their dust disease. And that includes hospital admission expenses, psychological support, pharmacy costs, nursing, personal care assistance, mobility aids, oxygen supplies, and domestic assistance. In addition to our legislated role of care and compensation, iCare takes a proactive approach to working with other stakeholders like Safe Work to create an awareness of dust diseases and support high-risk industries and impacted workers more broadly. An example of this is our lung screening service, which is provided free to workers and is heavily subsidised to employers where applicable. We also work with CERO-accredited providers to offer access to vocational programs to enable workers with a diagnosed dust disease to leave their hazardous workplace. So we take this inquiry as an opportunity to ensure continuous improvement across the dust disease care ecosystem. I'd also like to take the opportunity to inform the committee that we have recently gone through an organisational restructure at iCare and are still undergoing changes in leadership, including for the dust diseases scheme. And as interim Chief Executive Officer for iCare, and together with my colleague Rohit, who was the previous interim General Manager for the dust disease scheme, we will do our best to answer the questions from the committee. But we may also take questions on notice to make sure we're providing full and accurate responses to inform your work and any recommendations from the inquiry. So let me provide you with some background to the scheme and how it works. The dust disease care scheme currently provides support to approximately 1,500 workers and 3,500 dependents, with just over 334 of whom have been impacted by a diagnosis of silicosis or other silica-related disease. And when a worker is accepted into the dust disease scheme, they are assigned an appropriately trained case manager at iCare as a single point of contact, and that dedicated case manager is maintained for the life of the claim. And those iCare case managers ensure the workers, and where appropriate their families, are aware of the support available to them and help to identify the most effective support for each worker based on best practices. And our case managers provide guidance to the workers and their families in understanding the claims pathway, on what to expect in order to be able to plan for the future. They provide practical assistance with assessing financial entitlements and medical support as their needs change over time. And importantly, while there are no legislated obligations under the scheme in relation to return to work, iCare recognises the need to support people who are partially impaired due to occupational dust exposure, yet still of working age. And this includes younger workers diagnosed with silica-related diseases, who are encouraged by medical professionals to leave hazardous industries to eliminate their ongoing exposure to silica dust. And iCare's vocational assistance program uses CERO-accredited providers to help workers explore their employment options and transition to new industries if they choose to do so. The provider offers a range of support services depending on a worker's needs regarding their location, cultural background, and language barriers. And that includes retraining and skill enhancement opportunities, assistance with job seeking, interview preparation, and securing work trials. An example of this is iCare funded a laptop technology classes and an interpreting certification for a worker who wanted to retrain from a stonemason to be an interpreter. And other examples are quite expansive. They include assisted training through our program for a personal trainer, property manager, disability support worker, picture frame maker, and etc. So we also have psychological support. We also offer psychological support to workers by funding appropriately qualified psychologists and counsellors. Unfortunately, the current legislative framework does not allow flexibility to provide tailored financial support to meet the individual needs of our workers with silicosis, many of whom need support at a younger age. And these workers are often still building their careers and have many years of supporting families and paying mortgages ahead of them. iCare does what we can within the bounds of the applicable legislation. Back to this screening, iCare is the only subsidised screening service in New South Wales. We have a fixed clinic located in Kent Street in the Sydney CBD and a mobile lung bus clinic that travels across the state. iCare offers a team of expert clinicians who monitor a person's lung health over time, so they're in a good position to pick up anything unusual as early as possible. And those screening services are provided free of charge for workers, there is a significantly subsidised cost per worker to some employers, and that is approximately 25% of the costs of what is charged by commercial providers as a comparison. Our screening services are provided free of charge for employers in the engineered stone industry, and they are free for people who are retired or no longer working and believe they were exposed to harmful dust in a New South Wales workplace. Our mobile service is well used by the community employers across New South Wales, and last year our board approved funding for a new mobile clinic to be built to ensure continuity of service, as the current clinic, our popular lung bus, has reached the end of its life. And this is expected to be launched in early 2025 and includes the latest equipment and an innovative design. So every year, more than 5,000 people with exposure to dust through work in New South Wales get their lungs checked on that lung bus or in Kent Street, but we know that there are many more who should be getting their lung health checks. And according to the dust levy data, 78,000 workers in New South Wales work in conditions with hazardous dust levels, and we are exploring options as how to best expand our screening services and capacity. And we play an important role in the lung screening, but a larger market with a greater capacity is required to fully support workers across the state who are exposed to unhealthy dust levels. I'd also like to say that iCare is very supportive of the forthcoming Silica Work Register being developed by SafeWork, which will legally require employers in a high-risk Silica workplaces to enter their workers' details on a register. And iCare will have access to the data from the register, which will help us target more workers for screening purposes. And we have established routine meetings with SafeWork to facilitate inter-agency information sharing, aiming to strengthen our joint efforts to promote screening and prevention in our interactions with employers in this regard. I think my last point would be that I'd like to highlight is that iCare's Dust Disease Care team does a wonderful job of caring for workers of New South Wales who are impacted by dust disease. They are passionate and committed, and they focus on providing empathetic and proactive support for workers and their families when they need it most. And it is hard work, but we can wholeheartedly say that we are doing everything we can within the bounds of the legislative framework for those we serve. And our participant satisfaction within the dust disease care scheme remains high, with an average satisfaction rate over the last quarter of above 90%. Feedback remains positive, with frequent praise for our staff's professionalism, empathy, responsiveness, and personalised care. And we remain committed to maintaining that level as we move forward in optimising our administration of the scheme. And we look forward to working with the committee in this review. So thank you very much.
Thank you very much, Mr. Farquharson. Mr. Bandar, have you anything to add to that, or that represents the opening statement from the organisation?
No, nothing further to add from my perspective. Thank you, Chair.
Well, thank you. Present today are members of the Legislative Council from government, opposition, and two from the crossbench. The way we wish to proceed is, if you're happy with it, is to share the question between ourselves and provide a back and forth exchange of question answer. So we've got set down to in fact 11 a.m, so there's a decent period of time. I don't expect we'll exhaust before then, but if we do, we're just not going to hold you back for the sake of it, but I think there's likely to be a number of questions. Can I thank you for submission, which is from iCare and stands as submission number 12 to the inquiry. It's been processed, uploaded onto the inquiry's webpage, and obviously forms evidence to the inquiry in a written form, and we're going to obviously receive oral evidence from yourselves today. I might start with the questions if I could, and then we'll start to share around. Could I just go to page 8, please, of your submission? And thank you for that. It's a very valuable submission, particularly the data contained in the, what I think are 6 appendices. So thank you for that. But could I take you to page 8 first of all, please, under the heading Natural Stone? Can I take it as read and understood that in the context of where we are with dealing with silicosis or silica-related dust diseases in New South Wales, you're aware that we've moved in tackling and dealing with, not just in New South Wales, but at a national level, the situation in regards to manufactured stone and the banning that has come in regards to that. So there's obviously a legacy issue there that obviously will play itself out that we need to be very alive to. But that's been tackled in a legislative way, and I think we're aware of the laws around that. But particularly in terms of this inquiry, we're having a particularly close look at the silica-related dust associated with tunnelling, of which there's been much work done in this state since around 2012-13. And I have to say up front, to if you're not aware of this, that it's exercising the committee's minds in a most significant way, because we see it lurking there as something which has not received perhaps the attention it's deserved in terms of coverage in the public domain and, dare I say, in the political domain. But we're staring at it, and it's staring at us, and we are very keen to develop a report with findings and recommendations which is going to tackle it head on to significantly lift up what we're dealing with in regards to this matter. But on page 8, under the heading Natural Stain, can I take you to the third last paragraph on the page that says projections in relation to silicosis exposure are not reliable due to insufficient information being available. That's a significant statement about not being reliable. I'm wondering, can you elucidate on that statement? And I'm particularly interested in the data collection associated with silicosis. Are we in a position to say we are collecting detail with specificity which goes to explaining the source of where the silicosis has come from, or the silica dust has come from? Because we are particularly focusing on and want to get our hands around and head around the matters to do with the tunnelling.
Yes, certainly. What I can say is that ICARE is not yet seeing a trend for increased screening in the tunnelling and quarrying industries, but there has been an increasing trend by employers in these industries to use the services of private medical providers rather than utilising ICARE's lung screening and health monitoring services. And so that limits our ability to systematically collect demographic, workplace and health data and understand disease prevalence.
Which is the next paragraph, yeah.
And it also limits opportunities for us to ensure workers are aware of the support available under the scheme and how to access it. And as those tunnelling projects are generally run by major companies who are insured by Comcare, limiting our ability to educate those workers, they would not be eligible for the scheme under the current legislation. So I'm not sure if that addresses your question, but ICARE has reached out to offer health monitoring services to a major employer in tunnelling, which they've declined. There's a preference to use private companies due to a larger service offering.
Well, if I can cut to the chase,
Yes.
what the committee is particularly interested in is to hear your thoughts, and I'm speaking just a single member of the committee, and other committee members will have their own questions. I'll withdraw that. In terms of what you've observed since you've been in the role and have come to understand, and bringing into that previous experience that you've had, what can be done, in your view, or what should be explored at very least, of how I'll use the word the state, through its agencies and bodies, get our hands on, so to speak, the data that we need to come to understand the size of the issue before us, so we're not operating in the dark.
Okay. I think, and I'll let Rohit respond on that, but from September this year there are additional requirements in relation to the processing of silica substances, and these assessments in the workplace should help in ICARE seeing an increased demand for our screening services. I think that's one component of it. But of course we'll continue to monitor developments there. But I'll let Rohit respond to that because...
Sure, thank you, Stuart. So firstly, from a data perspective, SafeWork is working towards collecting the data and building out a register of employers that have exposure to environments that have got hazardous dust. Once, and so we're working closely with SafeWork on the completion of that register. Once we have the register, we have the opportunity to identify employers at higher risks of dust exposure, and then we can work jointly with SafeWork to target and prioritize screening services to those employers that are in greatest need.
Just a couple more and then pass on to my colleagues. That sounds like potentially quite a horribly slow way of the state being able to access accurate information in a timely fashion about exposure of tunnelling workers to silicosis. In other words, from exposure through to actually seeing data and seeing figures with some specificity. That would take, I would imagine, many, many months. Would you agree?
Thank you for the question. In terms of the register, that register is, SafeWork is looking to publish that register over the course of the first part of next year. So that's the time frame that we're working towards, and I can take that away on notice to identify more detail and how we can work better to get access to the data.
Okay, well, I've got more, but I need to share it around. So perhaps I'm over to Carl Boyd. Sorry, Carl.
Thank you very much, Chair, and thank you to both of you for coming along this morning. We've had a number of recommendations in other submissions and from other witnesses, and one of them does involve this issue around the private screening. The recommendation is that it just be made mandatory that we need to make sure that all workers exposed to dust in their workplace have access to an eye care screening. What is the practical implication if we were to do that in terms of, do you have the capacity to be able to do that screening? What would it look like? What would the lead time be and the resources required?
So if I quoted some numbers earlier around our current capacity and volumes, and if we're looking at 78,000 workers potentially impacted, our current capacity is around, it's over the 5,000 that's currently going through the system, but it's not anywhere close to the 78,000. So there would be, as I said, we're looking at options to maximise capacity, but there's a big difference.
Yep.
So that would not solve the issue.
Okay.
Alone would
Yep.
be my response.
The alternative suggestion in the submissions then is that there at least be some mandatory reporting back to iCare from the private clinics. What would that involve, again, in terms of, like, presumably you'd need to set up a system, there'd be a lead time. What would the resources look like for that as an option?
And I think it's a question that we should consider and get back to. But what I would say is that is some of the issue. It would allow us to proactively engage and do further screening. So I think there are benefits out of that.
Yep.
Practically speaking, from a reporting mechanism, I'm not sure what the demand would be. Rohit, do you have a view on that?
From what we know, there's there's 78,000 employees across the state that work in environments that have got exposure to hazardous dust. Out of that, we know that there's approximately about 26,000 that would require screening on an annual basis. As Stuart mentioned, we have the capacity to provide screening to approximately 5,000 of those employees. And there is a broader market that we need to work with that can provide and help meet that demand. So that's something that the dust diseases team is exploring options in terms of how best we can increase our capacity to meet increased demand.
But I think your question was around the implications of implementing a reporting mechanism so that we had that information.
Yeah.
And that's probably something that will require some consideration from us, because
Yeah.
how do we respond to that additional information we're saying it would inform us
Yeah.
to be able to be more proactive? And I think that's the point out of this.
Yeah, that's right. So if tomorrow, well, not tomorrow because we're not sitting anymore, but if next year we were to pass a bit of legislation that said actually all of these results need to be forwarded through to iCare in terms of, what it would then take, if you could come back on notice to sort of what that would then take from your side of things. But also I understand that when you've had an iCare screening, there's a follow-up mechanism.
Yes, that's right.
So building that also in to those workers who have had a private screening.
So my initial response would be the analytical side of it. You could probably, because it's about obtaining insight from that information, creating awareness so that we can be more proactive. So I would say, yes, there's going to be a focus required there, but importantly, for the follow-up screening and that proactive approach, we'll have to solve the capacity issue there.
Yeah, okay.
And I think we also need to work out how we build data sharing arrangements with the broader private sector providers so we can access the data, and then we have a consolidated view of how we can best report on those activities.
And I think that's what you're
Yes.
leading to, is what mechanism could we put in place that would
That's
help
right.
that.
Yeah.
But can I just jump in just quickly, sorry to interrupt. Data sharing, I mean, at the end of the day, if we just go back to that paragraph you were quoting from on page 8, with respect to the employers, there seems to me, from your experience, and correct me if I'm wrong, but there's some great reticence or reluctance to cooperate with respect to handing over data. Is that a fair assessment or a fair statement to make?
I'm not sure what the driver is, but yes, we are unable to, we do not have a level of insight into the prevalence of dust disease.
Has information been requested? And I appreciate you're in that role for a relatively short period of time, so please,
Yes.
that context I do understand if you need to take it on notice. But has iCare been quite assiduous in trying to get cooperation to receive data, and that you've met basically a brick wall?
Okay. I'll let you respond to that if you're comfortable too.
That's something we might need to we take away on notice, and we can come back to the committee.
Sorry, I cut Abigail off and then move on to someone else. Abigail, sorry, I cut you off.
So
Sorry.
I just respond with a different answer to that, which is slightly related. We did also make reference to the fact that we've been working very closely with SafeWork and CERA around data sharing opportunities. Now, it's not exactly the point you're asking about, but we are actively engaging on that area, and I think making good progress.
I mean, it's good that there's greater comity in the systems to enable the sharing and analysis of information.
Yes, that's right.
But I'm talking about getting the primary data in the first place.
If I could just finish on the dust screening, on the dust disease screening side of things. So just that reluctance you were talking about with the chair, is that from the companies themselves then to share data in relation to employees, or is it a reticence from sort of private clinics or employees to share that data across?
I think it's a broader reluctance.
Okay, thank you, that's useful. And then in terms of, no, I don't remember what my second question was in relation to screening. That's okay, I'll hand over to someone else and come
Thanks,
back.
Abigail. Might go to Bob Namvar, and I think Rod Roberts might have a question. Anyway, we'll start with the Honourable Bob Namvar.
Thank you, Chair. Just sorry to harp on about the data that iCare has available to it, but I think it is a critical issue.
Yes.
Would you agree, just in terms of accurately projecting the potential liability to the scheme
Yes.
of emerging hazards like dust diseases is entirely predicated on having accurate, reliable and public data sets available to you? I mean, how can you accurately predict the potential exposure of the scheme to these diseases without that data?
Should I talk a little bit about the process that we go through? We do have a very strong actual capability within the organisation, and we perform our half-yearly liability evaluations. So I'll also just talk a little bit about how we run the scheme. So we run this on a pay-as-you-go basis. and really what that means is that the scheme is funded, so there's always a net zero result. I know your point's a little bit different around how do we get insight into what's going to happen in the future, because that's really about the liability base that we have in the financials. We have, the scheme is $2 billion in claims liabilities, and those are funded through contributions and, of course, the investment asset base that we have, the investment returns and a drawdown on that. But we do significant modelling on the numbers that are coming through, and yes, it's important that we do have a handle on what's emerging out of silica. So your point is right.
But to do that modelling, you need the data, you need the monitoring data that's taking place, the actual exposure that's taken place. You can't perform a model on a range of hypotheticals, can you?
No, you can't. And the reality is that when you look at our claims liabilities at the moment, they are still significantly impacted by historical exposures. And so this is a new emerging exposure that we're talking about, and we're talking about practical ways to improve the data that we hold, and I think it's all absolutely relevant. But the substantial portion of our liabilities as they currently stand relate to historical asbestos-related claims. So I'm not sure if that helps. I'm agreeing with you. We do need to be proactive in terms of the new emerging risks that are coming through. Rohit, anything else to add on that?
No, nothing further.
Could I?
Yeah.
I suppose coming at this from another way, so there's the potential liability to the scheme. You'd agree that ICARE would be incentivised to see this emerging workplace hazard mitigated against in every workplace, because obviously that reduces the exposure to the scheme.
Yes, and I think importantly it helps us to provide support to people that are impacted, injured workers that are impacted through the exposure.
So, would you agree that beyond governments legislating, when there is an emerging workplace hazard that's presenting itself, like dust diseases, one way to mitigate against that emerging hazard is to promote and enforce better practices at each workplace? Is that a fair assessment?
It sounds fair, yes.
Is the promotion of data a key sort of factor in that? Having published public data available to everyone, with a view to driving better practices at each workplace with emerging hazards?
So I think there's two parts to your question. One was the promotion of safer workplaces, and then the second part was the utilizing of data to promote safer workplaces.
Yes.
If I start with the first part, so if we think about the promotion of safer workplaces and increasing workplace health and safety, that's the role of Safe Work. ICARE collaborates with Safe Work. The role of ICARE is to administer the scheme, provide treatment, care and support and compensation entitlements to workers who have been assessed with a dust disease. So the second part is in terms of the promotion of the data. I think as we've touched on, it is a small, but it's a growing cohort. And as we have access to more data, that gives us an increased opportunity to better project some of those future liabilities.
But sorry, can I just jump in? When you say small, with respect, we don't know what we don't know, and ICARE doesn't know what it doesn't know. So it may well not be small. Is that not correct? Because if people haven't been tested, we don't have data, we don't have accurate information, how do we know it's small? And I'm particularly focusing on the work with respect to silica dust in tunnelling. You can't say it's small, can you? you can say that the information you've got suggests it's small, but you don't know that it's small, do you?
That's quite correct. And I think the answer is that when you look at the claims that are currently being paid out of the scheme, the vast majority of them relate to non-silica-related diseases, and your point being that there's an emerging risk and trend, and we need to understand that. And just to support the position that Rohit was articulating there, is if you look at the number of applicants awarded benefits in 2024, 300, almost 400, and of that, new applicants with silicosis and payments in that regard were 80. So it is not insignificant, but it is smaller. And as you say, it's very important that we understand what is emerging.
And we heard in the we heard in the previous hearing that we had in relation to silicosis taking 10 years on average after exposure. We've heard a lot of evidence about concerns with air quality, particularly in tunnelling, and some submissions and witnesses have said that, you know, basically we're going to see a big wave of new workers being diagnosed with silicosis after working in tunnels. How, I guess, looking at that emerging risk, how, from a sort of a pure financial perspective, does iCare get comfortable with sort of how it can model its potential outflows in the future? Like, what do you need in terms of the information in order to do that accurately, given that you don't have that sort of screening data?
I think it comes back to the screening. The screening needs to be done, and we need to understand what is emerging out of that, and that's how we can best prepare for future exposure, really, or future illness.
Yeah.
In terms of the way the model is set up, and I spoke about that a bit earlier, we're providing for current claims as they emerge, but your point is about future claims, and that's really what the nub of this issue is how do we get to that. So it is about understanding that we're screening at an appropriate level, and we understand there is implications of what's coming out of that screening, and that technology is improving all the time, so we can understand and detect disease early, and so it's about having access to that ice.
So in terms of I guess the way that the health of the scheme at the moment financially, my understanding is that it's pretty good at the moment. There's a bit of, it's not under pressure.
No.
But there is a potential for these claims to really increase. What is the process then of ensuring that the companies responsible now are paying into the scheme to ensure that there's enough money in the future?
So this comes back to that point about the structure of the scheme, and as I described, the pay-as-you-go system means that effectively the claims that are incurred during a financial year are paid for out of the levies that are levied that year and collected, plus returns on the prior investment base. So there is an element of prior employers contributing to the current claims, but for future claims coming through, that'll be funded out of future levies, and to the extent that there are still investment returns, that will contribute to it. So those are the two mechanisms. So if there's a significant increase, that's largely going to be funded out of future levies, to answer your question. And so what is the mechanism to recover that from employers now? That the mechanism doesn't allow for that, other than the investment base that is utilised to contribute to those costs. Does that make sense? And
Is
help?
that...
I can.
Sorry, go ahead.
So we provide the total contribution data to CIRA, and essentially then CIRA looks at the experience across a range of industries to then determine the appropriateness of the levy setting. So where we see industries or companies with increasing exposure, then the levy setting will essentially be adjusted to factor in the rate at which the levy is calculated for those industries. So.
And is that a standard sort of model of doing this? Is there like examples in other parts of Australia or other places where there is I don't know if there's a way in which levies can be more accurately assessed against, I guess you'd need the data, but a future sort of claim pool rather than working on this kind of year by year? Is that just the way it is, or are there changes that can be made?
So each of the various workers' compensation schemes operate slightly differently across the different jurisdictions in Australia. We would probably need to just take that away on notice to identify where there's opportunities for us to learn from and identify different levy setting arrangements.
But I'm not aware of an arrangement that allows for the collection of levies based on future liabilities coming through in this area, but it may well exist. We can investigate and get
move
back
the
to it.
questioning just a little bit. So, did you have any follow-up across to the Honourable Rod Roberts? Because I think there was a back and forth between yourself and Abigail.
I'm happy to pass to Rod, but I've got some
Rod?
follow-up.
I only have a couple of questions, Chair.
Well, why don't you bowl them up? Yep.
Okay, thanks. Thank you, gentlemen. Thanks for attending today.
Thank you.
Could you, in the first instance, talk me through the actual screening and monitoring process of workers that are in high-risk areas for dust disease? What actually happens at Kent Street, for example?
Okay. All right.
What do you do?
Would you like to?
Yeah, sure. Thank you for the question. So in our Kent Street mobile clinic, we have we provide essentially three tests. So firstly, we have a chest X-ray for workers. Second, we provide a lung function test, and we also gather information on their medication, on their medical and their occupational history. And all that is reviewed by the clinical team to assess what the next course of action based on those set of tests are.
Okay, right. Well, that takes me directly to the point. I have sat on this committee for a number of years, along with some of my other colleagues here, and it's been explained to us that the best form of monitoring for potential detection of dust diseases is not chest X-rays. It is in fact CT scanning. How would you respond to that?
Thank you for the question. We have the Dust Diseases Care Team and iCare have conducted an extensive review on the deployment of CT scanning capability in both our physical clinics as well as our mobile clinics. What we've found from the review is that there's significant operational, financial and environmental risks associated with having CT scanning capability in both fixed and mobile clinics. There's an external market that provides very easy access to CT scanning services, both in metro areas as well as in regional areas. And so we act on the clinical guidance of our teams, radiographers and respiratory physicians. And where there's a need for further examination, or specifically CT scanning for a particular worker, we can offer very rapid access, and in many instances, same-day appointments where the team looks to coordinate the booking for those workers. So we find it very easy to essentially arrange access for those services via external providers.
Well, okay, there's a fair bit to unpack in that. So I'll put a proposition to you. You can either agree with it or disagree with it. In this case, we are not adopting best practice in terms of screening for potential diseases in workers. Because we've been told, and by predecessors of both of you gentlemen, that CT scanning is the ultimate detection tool, as distinct from lung testing and chest X-rays. So what the proposition I'm putting to you is that iCare is not adopting best practice immediately. So how do you respond to that?
So thank you. So So as I mentioned, we act on the clinical guidance of our respiratory physicians, and every worker who requires a CT scan to be completed is given access to completing the CT scan, and that's something that is paid for by iCare as well.
Shouldn't, as the default position, be that you get a CT scan rather than a chest X-ray? Should that not be the default position the moment someone presents at an eye care clinic? Let me put this proposition to you. Is it the best tool to diagnose potential disease?
I think that's a medical, you need a medical opinion for that.
Well, we've been given the medical opinion year after year after year from people that give evidence to this committee that CT scanning is the best, most reliable way. All right, well, you don't have to answer, you can take it on notice, right? But I'm putting to you that iCare is not adopting the best practice that they should be. And in your answer to it, you said, there is financial and environmental risks to us conducting CT scans. What's the financial risk to iCare in providing CT scans to potentially injured workers?
Thank you for the question. So the as we look at assessing the demand for CT services and the volume and throughput that comes through both our physical clinic in Kent Street as well as our mobile clinic. And based on the numbers that we see coming through, and we look at the data. So the data that we, based on where we are referring our workers to external providers to complete those services, the cost of having CT scanners and employing qualified technicians essentially don't justify, are not justified based on the volumes that we see coming through.
So I'll put to you then that iCare is not adopting the CT scan method because it's financially too restrictive. Is that what you're saying?
No, I think the point here is a little bit different. I mean, there is a financial consideration. There are also operational considerations, and we spoke about the fact that there's a nuclear medicine accreditation that could take 2 years. But the point and the advice that I've received, and we can come back to you on this, and we absolutely will to confirm, is that a CT scan is not applicable or necessary in every situation. And if I look at the information that I've seen, is that, and I quoted the numbers of workers that we screen through our processes, approximately 5,000 a year. Since 2019, we've ordered 1,200 CT scans. So what that implies and suggests, and as I understand it, is that a CT scan is not applicable for every screen or every screening instance. So based on the medical advice, where there's a need for that scan, then we will arrange for it. So that's the answer, but very happy to get into the detail of what you're asking and come back to you with that. The view is that it's not about a purely financial perspective. It's about the need and what is a pragmatic way of operating the screening.
Well, Mr. Mandama did say that it is a financial risk. They were his words that I repeated back to him. And he has said, and again, I'm not putting words in his mouth, and we're not here to do that. Yes. We're just here to get to the bottom, absolutely, to find the best treatment, the best diagnosis, and the best prevention to stop workers from being injured.
I agree.
And it was alluded to by yourselves that there's a financial risk in CT scans. Well, my concerns are we've been told that it is the ultimate tool, not a lung X-ray, not a chest X-ray, not a lung test, but a CT scan, and that's my concern that that's not being utilised. Okay. Move on to just one other subject, Chair, if you don't mind. Please. And that is, we've heard from witnesses here about cross-jurisdictional issues. So the tunnelling profession moves from state to state on big major infrastructure projects, and there's this conflict between where did the injury, and I use that in inverted commas, occur. Did it occur when I was a worker on a tunnelling project in Victoria, but I'm now here in New South Wales on a tunnelling project and I get screened? Can you talk us through that conflict and how can we resolve that to ensure that workers just get the best possible treatment available?
I may need to take that on notice unless Rohit is able to provide some insight into it, but it's about exposure within business places in New South Wales. So I think that's really the key trigger in this. That's the important point. Is there anything that...
We might take that away on notice.
Because we have heard, and I urge you to go back over the transcripts of the last hearing from a couple of weeks ago to hear what witnesses have said in relation to that particular issue. I'll give someone else a go at the moment, Chair, if you like.
Did you? I'm going to change tax.
Please do, yeah.
And I wanted to ask a little bit about the relationship between the dust diseases scheme and the workers' compensation scheme. So you've probably seen employees, maybe they've started off in the workers' comp scheme and then have been pushed over to the dust disease scheme. How does, could you walk through with us how that works, and would you say that one scheme is more generous than the other in terms of the financial, claims that are made by injured workers?
I think what I can say, is that we do have detail here, and we can provide you detail on the benefits that are provided under the dust disease scheme. But of course, a comparison of the benefits, I wouldn't be able to comment on that today. Practically speaking, I don't really have anything to add to that, so I'm not answering your question. My apologies. Rohit, anything we can add to that or to address that question?
We might just take that away on notice.
But like, surely you've got examples, or there would be many cases of workers that start off in the workers' compensation scheme and then are moved to dust disease scheme. Is that?
I can't comment on that. What I do know is what benefits are legislated for the dust disease scheme. I'm not sure about that transition, so I need to respond on that.
Yeah. Okay.
My apologies.
And the when injured workers are not at work and they're claiming the benefit under the dust disease scheme, what proportion of their income are they receiving as a benefit? Because some of the submissions saying that it's not. Some of the other submissions are recommending that it be lifted to around 100%. Is there a sort of ballpark figure of what that figure is?
We could quote the numbers as a percentage. I can't tell you, but I do know that there is a difference, and there often is a difference between what is paid and what would be the current wage.
And thanks, Stuart. So so to just provide an indicative view of the numbers. So if you look at our workers who are of non-working age, the current upper limits for fortnightly benefits are approximately around the $5,000 mark for the first 26 weeks. If we look at workers who are of working age, it's similar. So approximately $5,000 fortnight for the first 26 weeks. And then that amount steps down to 80% of that benefit, which is approximately $4,000 for the second 26 weeks.
Yeah, okay. No, thank you. Would you be able to comment on the financial viability of the scheme? Obviously, there's been probably more problems in the past with the workers' compensation scheme in terms of its financial viability than dust disease, but dust disease scheme seems to be going fairly well from a financial perspective. Is that a fair comment?
Yes, and it comes back to the point that I made earlier around the financial structure of the scheme and the pay-as-you-go mechanism. And effectively, we collect what is required to cover the costs on an annual basis, which means there's always a zero net result and an appropriate financial backing to the scheme. And if we just look specifically at where we are at the moment, we've got $2 billion worth of liabilities and $1 billion worth of investments, and those costs of the claims costs that are paid for over the course of this last year are largely subsidised by investment income and a drawdown on the investments.
Thank you. Final one from me, just a comment or recommendation from the Thoracic Society is, I'll just read this to you and then if you can comment potentially. They've said that the feedback loop between iCare and SafeWork New South Wales is inadequate, leaving workers exposed to further workplace risk. There is no mechanism to ensure that workers are obliged to be followed up by a healthcare practitioner, nor given appropriate resources and support. Is that something that you've noticed or something that does need to be addressed from your perspective?
So I can't comment on that specific example, but what I will say, and I mentioned it earlier, is I feel that we are developing and have a very good working relationship with SafeWork, and we are proactively engaging to find ways to enhance the collaboration. And I'd say it's with CERA as well, and effectively we have a tripartite mechanism between the three organisations to explore all options to share information so we can be proactive about addressing the risks that we're talking about today, and not just in this scheme but more broadly across our mandate.
Thank you.
Can I just return to the line of questioning about data? I'm sorry to do that.
No problem at all.
Can I just commence by putting a sort of context? I appreciate both of you are relatively new in your roles, and I don't say that in any disrespectful way.
No, that's fine.
But that's just a statement
Yes.
of fact. Do we have a serious issue in front of us that we need to be dealing with in terms of exposure of workers to silica dust associated with tunnelling, or don't we in the state of New South Wales? And if your answer is, and I ask you to be frank, if you don't, if you've not been in the role long enough, both of you, to be able to provide a yes or a no answer, that's fair enough. But can I tell you, I don't find, and wouldn't find the answer maybe as being anywhere near good enough. So with that qualification, I'll let you answer.
I believe there is a risk associated with silica exposure, and we're already seeing it. It's coming through the scheme. The extent of the risk is to be determined, and that's really the issue we have here, is to work out what that is. I'm not sure if that's helped or answered your question. It's not a maybe. Yes, there is a risk, absolutely.
Well,
And
please.
Yep. Go ahead.
and the SafeWork register that we touched on earlier will really help us understand and quantify the size of that risk and take a really targeted approach in terms of offering screening services to those employers and employees that are at greatest risk.
Can I just provide you with a copy of a submission made to the inquiry by a stakeholder? It's submission number 14. It happens to be the submission from the Australian Workers Union, which is a union that has significant coverage in the area of tunnelling. And can I take you to page 4 of their submission? Now, I haven't independently gone and tested the table and its accuracy, but this unit has provided evidence for a long period of time to inquiries to the Parliament in different areas and are known for their accuracy. If you look at that table, there are 16 projects, and we're looking at the period essentially 2014 through to the present. So we're talking about a 10-year, decade block. And that's where there's been a spike, a very clear, unambiguous spike in tunnelling projects in New South Wales. And you'll see that a total of 16, 7 are completed, and there are 9 under construction. Now, they are very large projects, and some of them probably fall into the category of a mega project, the sheer size. Now, can I say, iCare has an appreciation of that, do they? They would know that this has happened. So we're talking about what has happened. We're talking about 10-year period. In real time, this has happened. It's still going on. And the sheer size of these projects are something to behold. Now, iCare clearly understands the number of workers that have been exposed to silica dust in those tunneling projects, doesn't it? The numbers. Just in terms of, we're talking about very large numbers.
Yes.
On any fair judgment, even if we don't have accurate figures. Is that a fair statement?
Absolutely, and we've spoken about that number of 78,000 people
Yeah.
that are exposed to hazardous workplaces and dust,
So-
effectively dusting.
My next point is, we're not coming at you to attack you
No,
personally or organisationally, but to simply make the point that if there is this appreciation of the dimension, the large dimension, should there not be, dare I say, a stronger response than saying that there is an emerging issue, when in fact there is this complete black hole, or black tunnel, if I can use the phrase, of lack of information around where we are presently in 2024, about to go into 2025.
I'm going to let Rohit respond on that, but what I would just start with is, I think what you are saying is entirely fair. We think of the role that that iCare plays in this. It's our role to administer the scheme in accordance with the legislation. So there are all sorts of legislative considerations that are a matter for government, and that'll impact reporting and safety regulations and those types of things. We of course have been proactive and are proactive in terms of our monitoring and the creation of awareness. So there is more work that can be done and should be done. So I'm agreeing with you and hopefully answering that to a certain extent. Rohit, I know you wanted to add
Sure,
to that.
thanks. So if you think about just building on that point on the role, this is a matter that's really fits in the role of safe work as you look at prevention and better and raising the safety standards in these types of environments that have exposure to dust. Our role is how we can really focus on dealing with the diagnosis of the claim and the treatment of the claims, and ensuring that these workers, once diagnosed, are supported and effectively compensated post-diagnosis.
The challenge we see, or I've been observing, is that whether we're looking at yourselves and the ensuring role you've got, Sarah, and to be fair, we're hearing from them next, safe work, where we had them provide evidence at the last hearing, and you can read their evidence if you've not done so already, and the industry, the tunnelling industry, which is made up of very large contractors and a whole pyramid of subcontractors. If you take those four component parts, and there might be others, no one seems to be pretty anxious about this. Everyone's saying, well, we've got a role and we're doing our bit. But it just seems to me that it's like each are in their respective corners doing their bit, whatever that looks like. But we don't have a universe understanding of what the issue is and the major component parts working in sync to try and, first of all, get on top of, in the first instance, what we're looking at, and then obviously the matter of dealing with what's going to be appropriate treatment for the workers affected and ultimate compensation over time. I mean, it's like everyone's doing their bit, but the bits don't seem to be syncing together. Do you have a comment about that?
No, I do. We are engaging and collectively looking at the issues that face this scheme and the various other schemes under our jurisdiction. And I mentioned some examples of that earlier with the proactive engagement between those three entities in particular. But you're right, there's a holistic view of it required. And the more we can do there to provide insights, and we do provide insights and information, and provide data, so that the different agencies can proactively address this, the better. So I would agree and disagree. I think we are engaging and we are looking at it from a system perspective, but there's more that should be done and could be done.
And maybe on that system perspective, if I may, because we're also looking to build the technology that can interface with the register that's being developed. And once we've got access to the data, then we have the opportunity to be even more proactive in terms of targeting some of those employers and continuing to raise awareness amongst those employers on the need for screening their employees.
Could I just ask about the dust disease register? Presumably iCare utilises it for its purposes, whether it's projections and modelling and whatnot. But do you utilise the dust disease register at the moment for your work?
So can you clarify which? So
The New South Wales Dust Disease Register, the annual report that comes out, and the data that it collects, the incidents of dust diseases.
Yes, but we could come back to, I mean, unless you would like to address that now, we can come up with specific
So the
uses.
register that we're talking about with Safe Work, that hasn't yet been launched.
So the New South Wales Dust Disease Register, where notifiable incidents of certain conditions have to be reported by New South Wales Health to Safe Work.
The one that's now gone to federal.
So has that historically been utilised by iCare for the purpose of its projections and modelling?
It would be, and it's a component of a broader valuation exercise. In terms of the specifics of how that flows in, very happy to come back to you on that. I think that's what you're getting at, is to what extent we use that to inform our views of the future exposure. We can provide that on notice.
Yeah, but in terms of the existing register, yes. And in fact, we also contribute some of the data that goes into the register as well. So yes, that data is being utilised.
Can I ask?
Abigail Lloyd.
Thank you.
Sorry, Bob, did you?
I've got one more, but I'll...
Sorry.
Sorry.
No,
Please, get it out.
No, I'll go. That's fine.
Thank you.
I'll make you ask the question.
So, just coming back to another one of the specific recommendations that we had in a few submissions, and that's around expanding the list of compensable dust diseases. And I guess this comes back as well to this, this issue we're talking about. People are they're being exposed now, but it might take 10 years till they actually evidence some sort of silicosis. But also, we are seeing medical science get better and better, and identifying there's actually a huge number of non-respirable diseases coming out of exposure to silica. What is the process then for, I guess, including those? Have you done modelling around that? What is the potential for the scheme to sort of expand?
And cover what would be the cost consequences of that?
Yeah. And also, what is the process for bringing those diseases on? At what point of, I guess, causal evidence do we start treating them as being compensable dust diseases?
Sure, I can take
Okay, you go.
So, firstly, from a process point of view, if you think about currently, iCare would really welcome the opportunity for greater clarity of disease as well as eligibility under the scheme. And this would provide, so if you think about the current definition, it gives little consideration for diseases outside of the lungs. And so from iCare's perspective, we're supportive of a periodic review of the legislation, because that essentially is a process to keep up with the increasing, to your point, which is the increasing understanding of dust diseases. And that any update to the definition will also provide greater coverage as well as clarity for workers that have exposure as well.
So yeah, but I guess this comes back to the way that the scheme has been designed. If we have people right now who have illness because of their exposure to dust in a tunnel or wherever, and then that then gets brought into the scheme in 3 years' time, how will the scheme adapt to be able to cope with those extra claims? Is it simply that then the levy will be increased in that year?
Yeah.
Right.
So to the extent that there's exposure that's covered under the legislation, it's provided for in the current costs. But you're right, if there are conditions that emerge that are outside of the current legislation, yes, that would be a future exposure. So that is
Yeah.
an issue.
Right. Sorry, Bob. Did you?
Yeah. So just want to come back to the registry.
Yes.
State registry, now a national register.
Yes.
As I understand it, it has historically captured incidents of notifiable diseases rather than exposure above, workplace standards. Should the scheme have, or should the register have been broadened to capture exposure above standards, certain standards, as opposed to just incidents of respiratory illnesses, to give organisations like yours a greater insight into the potential liability faced in the future?
I'll let Rohit respond on that if he wants to, but my response would be additional information will always be helpful. It will help inform the various stakeholders, including ICARE.
So incidents above a workplace exposure standard should potentially have been a notifiable incident.
I think to the
for the
extent,
purpose
and
of the
I think
registry.
that as to whether it should be included in that register or not, I think that's an issue not for us to decide, but I think additional information would be helpful.
It assists with your modelling and projections.
Is that fair, right?
That's right. Well, and probably beneficial for other stakeholders that we've spoken about within the broader scheme as well.
On the issue of the current dust diseases scheme, it effectively, withdraw that it was essentially designed at a time when particular consideration was given to workers at the end of their life. That's historically how the scheme has operated. And it certainly wasn't at that time giving particular consideration to younger workers being exposed to silica type exposure and what flowed from that. That's your understanding, is that correct, of how the scheme was set up?
Yes.
So, in terms of looking at what could be done to the current scheme, if the government was minded to make structural changes to reflect better the dust diseases that we now as a society are dealing with, like silicosis or silica exposure, have you got any particular comments, or if you haven't, could take on notice about what could be or arguably should be some restructuring of the scheme that should be done?
I'll just start by saying that one of the dynamics that we need to manage through is when you have younger workers that are entering the scheme, there is an opportunity for them to potentially move into different areas of work, and so we do invest time and effort to assist with that, and we spoke about that a bit earlier. There are challenges around that transition, and that's around accepting alternative forms of employment while retraining, and the impact of that on current receipts from the scheme. So yes, that is a tricky area for us to currently navigate within with the existing legislation. Would you like to
Sure.
add to that?
Thanks, Stuart. So firstly, the reform is a matter for the government, but it's something that ICARE is very supportive of. Few of the opportunity areas from a reform perspective is, firstly, there is an opportunity to undertake holistic review of the legislative framework that the scheme operates in, and specifically the supports for younger cohorts of workers. We've also seen the changing nature of exposure, and so with some of the younger workers, there's an opportunity to review entitlements and also look at areas such as vocational training to help them retrain and transition to other occupations that have no exposure to dust environments.
On the issue of potentially income replacement for workers that have succumbed to silicosis exposure, and we're talking about young workers here, within iCare, has there been discussion, even informal discussion, about the capacity of the scheme to be able to sustain something in regards to income support, or that's not been something that's been considered
I think that
as a possibility?
I think it ties back to the point that Mr. Boyd was asking earlier about how would you fund that, and that would be through effectively through future levies. If there was a change to anything, it would have to be funded through a levy mechanism.
And with that levy mechanism, just forgive me, but in terms of when you, I think it was in your opening statement or soon thereafter, referred to the 78,000
Yes.
Entities, I presume are they individual entities there? So 78,000
That's individual.
dust levy, that's from your dust levy data.
Yeah.
So that's 78. So they are entities that are being basically levied presently for because the nature of the work they do or the work they conduct or operate under provides exposure of their employees or workers to dust. Is that an easy way to summarise it?
No, I think that 78,000 that I was referring to related to workers that had been exposed.
Oh, sorry. Okay, so that's I withdraw. Okay, so that's the 78,000 workers. So in terms of the number of entities that engage those workers, they could be basically employers. So organisations that have an employer-employee relationship directly with the workers, but they could also be organisations that actually contract through contract arrangements with the workers. Or you would have to take that on notice. I'm trying to understand that 78,000, the nature of their engagement with the entities and employers. Sometimes it's an employer-employee relationship.
Yeah.
Sometimes it's contractual. Sometimes there are other more informal arrangements.
I think they could be employed in a variety of
Engaged in a
manners.
variety
So
of
they
ways.
could be employed. I think, and I'm not sure if this is helpful, but what I think you're getting at is how did those levies find their way to the dust disease scheme? And effectively they're collected through workers' comp. CERA sets the allocation, and then those levies end up in the dust disease scheme. So over a period of time, if there was a change in the underlying costs of the schemes and the exposures, that would flow through that mechanism.
Yes, I know, I've got the numbers running the wrong way. So with respect to 78,000, on notice, are you able to provide to the committee the number of, I use the word entities as a sort of a generic term, that are actually paying the dust levy?
Yes, I'm sure we could do that.
On notice?
Yes.
Yeah.
And that would be linked to the workers' comp entities that are paying workers' comp premiums, because the levies are included in that and allocated through a methodology that is set by CERA.
And the levy is on a per capita basis, I presume, or there's a, I shouldn't presume, I suppose. What is the levy? And if you don't have the specific details, I don't mean to put you on.
I can absolutely give you some information on the levies. So, and I'll just step back a bit, and if you want me to rush through, please let me know. I spoke about the as-you-go basis,
Yeah.
and the net result. And as far as the legislation, per the legislation, the levy is based on the expected expenses of the scheme, and that comprises the benefits payments and the support costs. And I spoke about the mechanism and the link with the investment income and the drawdown of investment assets. I know you've asked me about per capita, but just to give you an outlook for the next year. For the next financial year, the scheme's estimated costs will be $158 million. Of that, $75 million will be paid by levy contributions, and $84 million will be funded through investment income and the scheme assets. If we look at this last year, $83 million was collected towards funding the scheme costs, so 83 of the 125 million. So what does that mean? And I think this is the nub of what you're getting at, is average employer contributions. It's a percentage of wages.
Yes.
And so for the last period, from 2019 through to the outlook for next year, it's 0.03%. In 2023, there was an increase to 0.035. And that levy that's been collected has ranged from about $63 million up to a high of $83 million. So in terms of what that means per capita, I can't tell you that, but I can get back to you on that. But it comes out as a percentage of wages, and then of course CIRA sets the arrangement. So ICARE provides CIRA with the total contributions amount required to cover the costs, as I've just described. CIRA then determines how to apply the contribution across the industries, and it's based on charging at-risk industries with at-risk workers by setting a percentage rate for each dollar of wages paid. So it's back to that percentage of wages. And I'm not sure if we could get to a per capita, but we could. And it's business activity, it's risk profile, and it's claims experience. All three of those things link into that percentage. So there is expect some incentivization out of that to run a safe environment.
Thank you.
Thank you.
Sorry, it's collected as the workers' comp insurance premiums, which is what I mentioned earlier.
Yeah, thank you.
Thank you, Chair. A number of the submissions talked about challenges people were having in the scheme in relation to a lack of support to find other jobs, and specifically talking about finding jobs that are going to pay the same amount. And I know that you, and that leading to them basically staying in their jobs longer than they should and continuing to be exposed. In your opening statement, you did talk about the levels of vocational support, but I see in the latest annual report, I think it was 20 people received vocational support in 23-24. Is that standard sort of year on year, and I guess what are you doing to try and increase the number of people who are getting that support?
Good question.
I might take, yeah. So firstly, ICARE acknowledges the importance of vocational support. It's not something that's currently mandated within the legislation. So ICARE has identified this as an issue and has been working closely with CIRA accredited providers to provide a range of supports that Stuart touched on in his opening statement, such as skill building, interview preparation, job trials, etc., which ultimately enable people to transition to other occupations and away from hazardous dust environments. So I think going forward, this is another area of opportunity as far as future reform is concerned, in order to have that as part of a legislative framework going forward.
So we need to, so that's a legislative change to try and mandate it so that then we get higher levels of vocational support.
High levels of vocational support, yeah.
Okay. Is that a similar then answer in relation to a lot of the submissions talked about the lack of psychological support? And I know you touched on that in your opening statement as well. What do we need to do in terms of legislative reform to ensure that people get psychological support at a very early stage of their diagnosis?
So we've made the point that we do provide that, but it's a similar dynamic as I understand it. Right?
Yes, and probably the other thing I'll add with psychological support is that in many instances where it's offered to workers who have a mental health condition as a result of the dust disease. It's in some instances not taken up as well. So that's there's an additional barrier there from a worker perspective.
Yep. There was a recommendation in one of the submissions in relation to, it was around this issue where you can sometimes get payments out of the scheme that then push you out of getting a Centrelink payment or other type of government payment. I understand that I think under the federal legislation they have a thing where basically you can reduce payments to make sure that doesn't happen to a person. Is that something that you think we ought to be doing in New South Wales as well? Is that something that's crossed your path?
Do you have a view on that, Greg?
We might just take that away on notice and
that would
and
be
come
really,
back to you with a position on that. So
that would be really useful.
Yeah.
Another one of the recommendations was that we increase the 26 weeks of support to 52 weeks. Again, from an iCare perspective, has there been any sort of modelling around that? Is there any, what would that do, I guess, in terms of those yearly levies?
Yeah. We could absolutely provide that information, but it's the same principle, as you say. It's not currently built into the existing mechanism. If
Yeah.
there was a legislative change on that, there'd be a higher cost that would need to be funded through this mechanism.
Right. Has there been any modelling done in relation to those other 2 points, in relation to psychological support and the costs of including vocational support as a legislative measure as well? Is this stuff that's readily available?
I'd have to come back to the extent of what insight we've gleaned and what modelling has been done. Yes, you know.
there's been some very, very preliminary modelling, but we will come back to you. And in terms of psychological support, it's also looking at how not just the worker, but how their families as well can be supported and have access to services such as counselling, etc.
Yeah. Okay. Thank you. I think that's all I have now.
Yeah, I think the Honourable. Bob and Rod. Okay.
Yeah, I've probably just got one more in the time remaining, but I know you've touched on it in your submission, but I am interested if you could spell out in a bit more detail how the scheme differentiates between income support for younger people that have greater working capacity in the future and probably those who are of more mature age that don't. How do you sort of differentiate the income support that you provide to those groups?
Okay. So firstly, the income support is on iCare is based on the frameworks that we have within the legislation. So as I mentioned earlier, for people who are in retirement, there's income support for the first 26 weeks, and then it drops to the statutory rate post that first 26-week period. And for the younger cohort who are still in of working age, there is 2 lots of 26 weeks, as I mentioned, and post the 52-week period, then income the support drops to the statutory rate. But essentially, the differences in income support is mandated by legislation.
Can I just squeeze one more in if I could? Just in regards, and just returning to the issue of Comcare and what we understand to be some of the large companies, the largest even, doing this work, having their insurance coverage with respect to their workers covered in terms of Comcare. Perhaps we put it this way, what do you understand is happening with these large companies? Do you have any sense of, with respect to taking out their insurance coverage for workers with Comcare, and what might be the motivation behind that, if you've got any sense of this, and what is the implications of it looking at the whole system in New South Wales. So we've got the large companies acting in a certain way. What's your thinking around all of that since you've come into the role, and any assessments you've done about it? I'd be very keen to hear your observations. But both of you.
We might take that away.
On that?
So firstly, thank you for the question. That's something we might just take away on notice and come back to the committee.
Would you, Eddie, comments, or would you like to just...
No, I think that's
Wait to take that notice? Okay. Well, gentlemen, thank you very much. Hopefully you didn't find it too inquisitorial and too tough. We really do appreciate both of you coming along, first of all, and appreciate you in the roles that you've got. They're very important roles, and we appreciate the work you're doing. You can see that there is a sense of concern by the committee. I'm sure you do, because we don't want to find ourselves as a committee, and the successes on the committee over time, and there will be those looking back and saying, why wasn't more done, or why wasn't there more urgency injected into this? Why were not people sort of on the rooftops shouting if that's what should have been done at the time? And we just have the great, some of us have been through, and Rod Roberts made this point, have the memory of asbestos and the legacy that's still there, and indeed much of what's supported by the scheme is related to that. We went through the manufactured stone experience and had a number of matters brought to our attention, and that's been addressed, not completely, but in a significant way. And we just think we're staring at something quite large here, and we feel under-informed and potentially under-appreciating what we're looking at, and therefore that's making us somewhat anxious. So, yeah. So thank you very much. You've taken some questions on notice, so thank you for that. And I expect there'll be some what are called supplementary questions that will flow from reading Hansard by the members after today's hearing, and bowling up some further ones for you to have a look at.
Right, very good.
Thanks very much.
Thank you for your time, and
Thank you.
hopefully that was
Thank you.
helpful.
We'll break for morning tea and be back at 1:15. Thanks. Welcome back, everyone, after our short break. And we have our next witness from Sarah. Could I ask you, this is part of the formality, in terms of being sworn or affirmed in, to provide your name, your job title, and to swear either an oath or an affirmation, whichever you prefer, the words of which you should have in front of you. So thank you very much.
Sure, thank you. So I'm Mandy Young. I'm the Chief Executive of the State Insurance Regulatory Authority. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Rajan, and thank you for joining us this morning. Can I commence by inviting you, if you wish to do so, to make an opening statement. Followed by that, we have members on the committee from government, opposition and crossbench, and our format is pretty much a free-flow one, if you're okay with that, where we sort of share the questions between ourselves and there's a back-and-forth exchange. So are you comfortable with that, if after the opening statement?
Yes, sure.
So please proceed. Thank you.
So thank you, Chair, and thank you to the committee for inviting me to attend today. I'm here in capacity as Chief Executive of CIRA. Before we do proceed, I just wanted to take a moment to acknowledge the individuals and families who have been deeply affected by dust diseases. The conditions profoundly alter their lives, and their impact resonates far beyond the individuals that may have received a diagnosis. It touches loved ones, workplaces and communities. To those who continue to endure these challenges, I give my sincere respect and commitment to making sure that this inquiry is supported by CIRA and we can contribute meaningfully to addressing some of these issues. The Dust Diseases Scheme plays a significant role in supporting the quality of life for workers who suffer an occupational dust disease, and that support extends to their dependents, and the scheme assists with compensation benefits, medical and healthcare and support services, including domestic assistance and mobility aids. And it acts to be a critical social safety net for the people of New South Wales who suffer an occupational dust disease. CIRA regulates the workers' compensation and motor accident and home building insurance schemes, and as the committee will be aware, the occupational dust diseases are expressly excluded from the principal workers' compensation scheme in New South Wales, and instead the claims for compensation for any of the 19 prescribed dust diseases are dealt with under separate legislation. So that's the Workers' Compensation Dust and Diseases Act of 1942, and iCare acts for the Dust Diseases Authorities and manages the fund. So the Minister for Work, Health and Safety is that responsible minister. I don't think I'm telling you anything you don't already know.
No, that's fine.
However, the Dust Diseases Scheme isn't subject to independent regulation of claims, conduct or prudential functions, as would be the workers' compensation or any of the other schemes that we have oversight of. And we do not have direct regulatory oversight of the scheme. We play a very limited role in the scheme, though, in two areas. So firstly, as defined in the Act, we are responsible for determining the insurer or classes of insurers required to make contributions to the Dust Diseases Fund, the amount of any such contribution and when the contribution is to be paid. And secondly, we are responsible for indexing the compensation payment for dust diseases. So broadly based on the pre-2012 Workers' Comp Act 1987 provisions and death benefits prescribed from Section 8 of the Workers' Compensation Dust and Diseases Act. So beyond this, we are actively engaged in supporting both national and state prevention initiatives through the heads of Workers' Compensation Authority and Safe Work Australia's Workers' Compensation Strategic Issues Group. We're available to provide support to iCare and Safe Work in whatever aspect we can in respect to the important scheme that is the Dust and Diseases Authority, and we would do that within the scope of the workers' compensation landscape. So I thank you for the opportunity to support the committee and happy to answer your questions today.
Thank you very much, Michelle. And can I just acknowledge and thank CIRA for its submission, which stands as submission number 4 to the inquiry. It's been received, processed and stands as a submission and as evidence, along with what's going to be now your oral evidence. Can I take you please to page 3 of the submission, point number 2, and specifically point number 2.1 regarding to the Dust Disease Scheme levy. And I'm wondering if you're able to provide some insight and as much detail as you can, and the difference you can take. I notice you need to do so. In terms of how assessment is made and consideration given to movement of the levy over time. And I say that in the context that the scheme comes out from a long history, particularly with respect to particular dust diseases, such of which are being less contracted today than once they were some decades ago, but now is moving through and going ahead into the future with dust diseases which are somewhat different, and particularly silicosis is the one that's exercising our mind, and particularly silicosis or silica dust and silica dust in the context of tunnelling in New South Wales. And I'm interested in the way in which there is, I guess, the methodology and the calculation done and the underpinning assumptions behind looking at what should be adjustments over time.
Sure. So I can give you my best answer. I will note I've been in this role for 6 months, so I'm still working through how some of these are applied. And if there's anything in particular that I don't hit on, please just let me know and I'll get that to you on notice.
Thank you.
But if I just kind of take you back to, and I understand that iCare previously gave you some advice in the last session, so if I'm also repeating what they've said, then move me on.
No, you answer it as you wish to do so. Yeah.
So the Dust and Diseases Care is funded through a combination of the annual Dust and Diseases Levy and the employment and investment returns from the Dust and Diseases funds. It operates as a pay-as-you-go funding method, with the annual levy offset by the investment returns from assets built up in past surpluses. So it has about $1 billion under management, as I understand it now. So each year, basically, iCare informs us of the estimate expenditure from the fund based on the actuarial advice for their financial year ahead. So the example that I'd give you guys, I think it's often easier to understand in context, is that in 2024, iCare estimated the expenditure to be 158 million. iCare also estimated that 84 million should be funded from the existing assets of the fund. So that balance of 75 million was to be paid by contributions by insurers, which is often referred to as the Dust Diseases Levy. So we engage our actuaries to assist in setting those levy rates and allocating each of the 535 workers' compensation industry classifications into 9 levy schedules. So there's 9 risk base for the Dust and Diseases levies. So everyone would fit into those. And so the levy is a percentage of the wages. So the actual percentage applied through those 9 risk levels ranges from 4%. So they're employers who are directly involved in handling or processing asbestos and other component risk issues, to 0.0045%, which is the lowest risk employers, so like a hairdresser or a lawyer or something of the like. So those lower risk industries pay much less in terms of the Dust and Diseases levies. So the target average levy collection rate
Sorry to interrupt you.
Yeah.
Just with respect to lawyers, that's sort of interesting. What circumstances are you saying that all lawyers or the profession of law in New South Wales pays a levy, or just some?
Every insurer will pay a levy. So every employer will pay a levy through their insurance. So there's 535 industries considered. They fit into those 9 risk categories, and those 9 risk categories will go from 4% to 0.00.
Thank you. I was not aware of that. Thank you.
So everyone contributes something. There is potentially, and you could be a lawyer working in an office and have some exposure to asbestos, potentially. So can be a risk, but that's how the scheme's currently set and how we set the levy.
Sorry to interrupt.
No, that's fine. So we then publish the dust disease notice with the interim contributions on our, and we then collect those levies through the premiums. So that's the short version. Obviously, there's a lot of technical detail behind that in terms of how they're calculated and what that is and what that means for everyone. So that's how we calculate how much each insurer would pay.
So specifically, just following on, and then I'll pass to my colleagues, with respect to exposure to silica dust, that can occur in a number of ways, as I'm sure you would appreciate. There's been the manifestation of a lot of exposure through manufactured stone, which has been legislatively dealt with now through the banning of it. But there are instances that one would include stonemasons and stonemasonry work, mining and quarrying, so we're talking about not subsurface work but surface work, and in building and construction, and then tunnelling. And our focus obviously is tunnelling in New South Wales and tunnelling virtually in the main, if not exclusively, except for the Snowy Mountain 2.0 in the greater Sydney metropolitan area. If we took tunnelling as an example, tunnelling, I presume, doesn't fit as an industry category by itself, or am I wrong?
I would have to take that on
No,
notice
that's
in
okay.
terms of the technicality, but certainly manufacturing and mining and all of those various other forms would. So it's likely it would be a higher risk category, but I'd take that on notice to confirm.
Okay, well, yeah, that's what I was getting to, that I'm interested in the hierarchy of risk in terms of where tunnelling sits. So let's assume for the moment that with respect to tunnelling, it's an assumption, and we'll find out from your answer to the question on notice, that with respect to tunnelling, let's assume it's a more higher risk than, say, above ground quarrying. Let's make that assumption. That with respect to then the levy, that the employers pay a percentage which is higher than otherwise would be for a lower exposed industry or sub-industry. Is that correct?
That's correct.
Yeah. And with respect to taking, say, tunnelling, or indeed take some other subcategory, are you aware whether from time to time there is internal reviews done by CIRA about the classification grade and whether or not that classification grade with respect to the levy should be altered or changed?
So I would again take that on notice in terms of whether we do. It's an annual process that we go through. I would expect that we would look at the risk classifications regularly, but I will take that on notice to see.
Because what's behind my question is that if that's done, particularly what criteria gets considered and what is the mechanism for this potential review of the gradation of an industry or a sub-industry with respect to potential risk.
Yeah.
So anything you can provide in regards to that, but very much interested in the mechanism of how that's done, if it is done, and any historical information about where that's been done in the past and those results.
Yeah.
Perhaps if I pass it to other colleagues.
I'll go that way.
Abigail,
Happy
Boyd.
to. Thank you. Thank you very much for appearing and giving us the benefit of your expertise. It strikes me that this scheme is quite flawed on a temporal kind of basis. So if we're applying at the moment 9 risk levels to insurers based on what the particular operations are. So as the chair was saying, you'd expect a higher risk for tunnelling, etc. But then those risks aren't realised until much further in the future. My understanding is that you can't sort of bank that money for the future. So it's the amount that gets determined is based on what gets paid out in a year, not what's going to be paid out because of that particular employer in 10 years' time. We heard from iCare earlier that they have very, very limited data when it comes to assessing the prevalence of exposure to silica and what it is actually looking like in terms of the worker population. How does all of that factor in to then CIRA's determination as to whether or not an amount that's being levied that year is really sufficient? And do you think that we need to make sort of more fundamental reforms to the scheme to build in that consideration of temporal risk versus realisation of the risk?
I think that's a great question. I think I would say that the Dust and Diseases scheme is funded adequately for each year because of the pay-as-you-go. So that's the real advantage of it, right? We know exactly how much, well, not exactly, but roughly how much will be paid, and we can get that amount together to be able to do that and put the levy in place for that. We're the only jurisdiction that has a standalone dust scheme, so I think that's an interesting thing to note. So we're the only, there may be other personal injury schemes that have a pay-as-you-go model. I'm not sure, I'd have to look into that, but we're the only ones that have an actual dust scheme. So, but one of the advantages of the pay-as-go is that we collect enough to meet the claims, the cost of the claims for the year ahead, and it's fairly predictable. So that's absolutely the advantage. But the disadvantage is that employers in the future may have to pay. So I think that's, to your point, for the failings of the current employers in terms of the work that they're doing and the risk to their workers. So it's mitigated in part by the ability to draw down on the assets of the fund, so the ability to draw down on what is currently that $1 billion, roughly $1 billion, I think it's just under, that current and past employers have contributed to. But I think we'd really need to explore that from an actuarial basis to understand that. So I think there is some work to be done to understand that, particularly given that we are looking at the rise of silica exposure and what that might mean. So I think that's definitely something that we should
So how
start to
is
think
it
about.
determined, that amount that then sits in assets, I guess? Is that just the surplus from the year that gets booked, or is it actually built into the amount of the levy to ensure that there is a certain buffer?
I'm not sure of the answer to that. I'd take that one unnoticeably.
Thank you. I have a question before I hand over to someone else. By having this kind of, what I keep calling a temporal problem, I guess we're creating a bit of moral hazard as well in the scheme, in that you've got employers now paying less than perhaps they really ought to be responsible for, but then they could have disappeared by the time we get to the realisation of the harm that they've caused under the scheme. Are there any other, I guess, aspects of everything that iCare is running in New South Wales that has that sort of element in it, or is all of the rest of it?
So the rest of it is on a pay-as-you-go levy-based format.
Yeah,
so
it's just this one.
It's this one. It's the only one.
Thank you.
The Honourable Rod.
Chair, if I may, just following along, Ms Young, on a similar thing, and I'm looking for your advice and guidance here. And we won't nominate any particular real-life companies, but let's just say there's Company A, who is engaged in the tunnelling industry, and there's Company B. Company A, we'll use the terminology, is a cowboy outfit. Numerous recordings of high exposure to dust and potential silica dust, etc. Company B operates to the best possible practice. Am I understanding it correctly that we're both in the tunnelling industry and will both therefore pay the same premium, even though Company A has demonstrated that they are a much higher risk to workers and in fact the scheme? Am I correct in that?
Yes.
And I don't want to put you in this position, I realise you're new to it and you may not want to answer this or can't answer it or whatever. Doesn't seem like a very fair equation then, really, does it? Where one, both pay the same, but one's a lot less of a risk than the other one. How can we address that in some way, do you think?
So I think, again, it's probably something I would take on notice to think more
Sure,
about.
I understand that. That's no problem.
I think, as I alluded to before, I think there is definitely definitely a benefit to us looking into this a little further, given the changes in what's happening within the dust and diseases component areas.
So I'm talking about where there's been notified incidents, work covers, safe work's been involved, etc., etc. So we're able to demonstrate that there's been a number of breaches through negligence, perhaps. And this is my own personal thought, that company should be held a lot more responsible than the good company, and therefore should perhaps be paying a higher premium. because of their risk exposure.
I understand what you're saying, but in the current settings we have, that's
Yeah,
not how it
I
works.
understand,
Yeah.
not in the current, but perhaps that's something that could be looked at in the future.
Again, I'll take that on notice and
Sure.
You have any other questions?
No, you keep going.
Okay.
You know what, Eileen?
Thank you, Ms Young. My questions are probably a bit broader. Excuse me, sorry. How can CIRA's regulatory expertise contribute to improved outcomes for dust disease patients under the current scheme?
So under the current scheme, we don't have any authority in terms of a regulatory component. We do work regularly with CIRA and Safe Work. We work closely together on a range of issues, and particularly more closely together over the previous months. And since I've been enrolled, we have a tripartite group where we actually meet, I think we're meeting monthly at the moment, to work through a range of things around all of the schemes in which we work and how we do that. But in terms of dust and diseases specifically, we have and we do, I think, as iCare alluded to this morning, they use our approved providers for some of their vocational programs, and we're definitely having further conversations around how can we think about how we can do things. So legislatively at the moment it's quite constrained. There isn't actually anything to do. But from an administrative point of view, there may be some things that we can do to support them in terms of where they don't have some of those other broader programs that we might have through the workers' compensation scheme, and where they can learn from that experience. So we're having those conversations quite consistently and thinking about also data and other components to which we can share.
Okay, thank you. And are there any insights from, say, other schemes that can directly benefit the dust diseases scheme that you can think of?
So I think when we talk about people who have an injury at work, there are definitely some similarities. And as I said, we're consistently working with iCare and Safe Work on that and our learnings in that space. And I think certainly when we talk about return to work or changing vocations, or we're talking about psychological injury and accessing services, they're the sorts of things where we do have those collective conversations about how do we actually support that, how do we make sure that the broader ecosystem can support those injuries. So I think we're definitely doing that and having those conversations and thinking about where it makes sense for us to work together on those things. And we'll continue to do that. But from a current standpoint and how the legislation fits, this would all be done sort of more administratively in the background rather than within the current legislation.
Okay. And I think Ms Boyd I may be sort of repeating this question. So what measures can improve the alignment of, say, levy contributions with the scheme demands?
So again, I think that's where we would take that away and have a think about that and about the risk ratings that we have and what that means and what that looks like.
And so if we were looking at your submission, from what I can gather, there's sort of 3 key recommendations from the submission. And so correct me if this is just me summarising. So I would say promoting interagency collaboration to align the principles and the practices across the jurisdictions, and then sharing the best practices from other injury compensation schemes. And then the third being maintain sustainable funding while accommodating the scheme's evolving demands. Would you say that would be, am I correct in making those assumptions?
Yeah, I think that would be correct.
Okay. All right. To you.
Thank you, Chair. Returning to the matter of the levy, if I could please. What we're trying to do in this inquiry is obviously, as you know, the inquiry is looking at the review of the dust disease scheme, which is statutorily one of the requirements of this committee, and it's this scheme's turn in the cycle. But we're looking particularly as sub-areas the issue of exposure of silicosis to workers beyond that of the manufactured stone, and also the impact on young workers. In terms of getting the tone right about what we as a committee should be saying and reflecting in a report with findings and recommendations, that we conclude. If I was to take the evidence, and the committee took the evidence from iCare, Sarah, and Safe Work, on the issue of risk, or what's potentially coming down the line, so to speak, we get phrases like it's an emerging issue, or it's a matter that we're monitoring and looking at and observing and keeping an eye on. But I have to say, there's no sense of urgency, it seems, of getting on top of what I could sort of describe as sort of well-known phrase, the unknown unknowns. So if I could just use this example. You spoke about, obviously, the work done by your actuaries in looking and providing advice to yourselves, Sarah, the organisation, about increases or perhaps changes to the fee. Now, we heard from evidence earlier today from iCare that on their figures there's about 78,000 workers at risk, roughly about 78,000 workers at risk. And iCare manages on a rolling basis about 5,000. So there's this huge gap of knowledge of, first of all, exposure and how people may have been progressively affected by the exposure. How can actuaries provide you with advice when that's just not being taken into account because we just don't know?
So the actuaries can only
Accurate
work,
advice.
yeah. So they can only work with the data that we have. So I think that's an important note. And there are definitely ways, and I think this is one of the important opportunities that we do have, particularly with iCare and sharing that data to understand what is potentially coming down the line. So if they know that there are 78,000 people who may be impacted in the future, then we can start to work with our actuaries and their actuaries through to think about what does that mean for the future of the scheme, and to do some data modelling on that. You know, the more information that we have, the more that we can do. I think it's, you know, I'm very new to this, but it seems to me that us really getting into the bottom of the detail of this scheme has been really helped, one, by this committee looking into that, but two, I think by us having more conversations about how we work and what we do and the data that we share. So I think as we progress, we will continue to get better at that predictive modelling as we get more information at hand.
Is there any sense, so take it as read, that you're new in the role in the organisation? Were you in the organisation before you were promoted, or I
came across, so I was at the same level but in a different role.
Okay, so within the organisation itself, Sarah, is there a heightened sensitivity about the issue of exposure to silicosis dust compared to other matters that they might be dealing with in terms of threats to employee occupational health and safety matters, would you say?
So because we have such a limited role in this particular scheme, there are probably very few people within CIRA working in CIRA who actually work on silicosis. It would only be those who help provide the support around the dust and diseases and how we set the levies. So because it is
on notice, if you wouldn't mind providing to the committee what that number might look like in on headcount, if you don't mind, please.
Yeah, I could provide that on notice. I think it would be quite small because it is, once a year we set the levy. But from a broader perspective around silicosis awareness and what that means and what that looks like, there's definitely a heightened awareness and a heightened view of what we are doing in that space, and particularly the work that we've been doing nationally with the heads of workers' compensation. So we've been working together to develop some key principles for working working across Australia and compensation schemes across Australia for particularly the use of silicosis, but any dust-related diseases. So that certainly heightened the work that we've done. And obviously because we work closely with Safe Work and they've got a very heightened experience in this area, some of the conversations that we have are also around how do we support that work and what does that look like. So whilst the role that we have in the current scheme is very small, the broader issue around the impacts of dust and diseases is very clear within CIRA, and we do have those conversations and think about where and how we can support.
Just one final one before I pass on. With respect to the what I'll describe as the tunnelling operators, those that do the tunnelling construction, let's call it an industry or a sub-industry, whatever you like to define it, that there are a number of large players, I'll use the vernacular, and with respect to those large players, the evidence is, in general terms, there's been somewhat of a reluctance or lack of cooperation, my words, of providing information and detail about matters to do with exposure of, or potential exposure of workers to silica dust. Does CIRA have dealings through its process with respect to the setting of the levy, dealings directly with what I would describe as tunnelling operators in your discussion? In other words, say for example you're going to increase it, do you go out to market and say, listen, this is what we're proposing to do, and provide a consultation mechanism?
I'll come back to you on notice just to be clear around that, but as I understand it, we set the levy, but we don't have a consultation process with them.
Okay, because I was just interested in whether or not you're receiving any, well, if feedback's not the word, any sort of flow of information back from the operators in terms of what they're saying about the industry or the subject. The Honourable Abacabo.
Thank you. I just wanted to pick up on those principles as part of the HWCA working group. In the submission, it was prior, whenever it was put in October, it was prior to then the October and the November meetings where they were discussed. Is there more, do you have sort of an update on what's happening with those principles?
So the chair of the Heads of Workers' Compensation has provided them to Safe Work Australia and proposed that they do some consultation on the principles that were provided to them. So that happened in November, as I understand it. So it's back with Safe Work Australia to go on and do that consultation.
And around given the heightened awareness of silicosis and the risk to workers, around that sort of federal table, is there also this growing awareness around the risks from tunnelling and everything else, and not just manufactured stone?
So I'm not at the table necessarily because it's the Ministers for Work Health and Safety and our Safe Work are the representatives. However, in my conversations with the head of Safe Work, so Trent Curtin, and definitely in terms of the heads of workers' compensation, we are absolutely having those conversations as a raised awareness around silica and other
and
diseases.
in the other states, is there has there been a consideration, to your knowledge, around the non-respirable dust diseases and including those? So I understand in a lot of the submissions there's a sort of a bunch of other diseases that have now been associated with silica exposure. Is that something, to your knowledge, that is appearing on the sort of compensable diseases of the other states and territories?
So I'd take that one on notice. We can certainly come back to you. There's definitely conversations about it, but I'd take on notice whether it's actually appearing in compensable injuries.
Yeah. Thank you.
I think you may have answered this question, but if you don't mind, I'll just ask again, just to be certain. That with respect to the regulatory role of CIRA in the dust diseases scheme, other than the work done in the setting of the levy, it doesn't have any other regulatory role?
No, it does not.
So the actual setting of the levy is the only role. In terms of...
sorry, can I just correct it? So it's the setting of the levy and also the indexation.
Sorry, yes,
Yeah,
and its movement over time.
Yes.
No, forgive me. No,
very
that's
limited.
Understood. With respect to what might be described as the ongoing work or cooperation or engagement with Sierra and iCare and WorkSafe, are there occasions where all three entities are in the same room meeting and talking and discussing issues, or is it sort of paired off where you might speak to one and the other but not the three of you?
We meet regularly, so the three heads of the organisations meet monthly at the moment, and we have regular discussions. They can range, and the topics might range depending on what's happening at any given time. So yes, generally, as well as that, our officers will meet regularly to discuss.
May I ask, who
issues.
prepares the agenda for those meetings? Are the heads?
So I'm currently the chair of that group, so we prepare those meeting minutes.
Has the matter of silica dust exposure and tunnelling been on your agenda in recent time?
As a specific issue, no, it hasn't.
Well, given that this inquiry's been going for a few months now and people have been belling the cat for a lot longer than that, I find that a bit surprising.
So I
guess the caveat would be that you're in the role for a relatively short period of time, so I acknowledge that.
So can I just sort of add into that? So yes, been in the role a relatively short period of time, as has Stuart Farquharson
Yes.
and Trent Curtin. So we're
Yes.
all relatively new. In saying that, it hasn't necessarily been its own agenda item, but we have discussed it. And in fact, at our last meeting, we did discuss it.
And may I ask, what did you discuss about?
So we discussed that the inquiry was coming up, and we were having conversations about what are the key issues that we had in these areas.
And with respect to Sierra's thoughts and reflections about key issues in this area, what were they?
So for us, again, we have such a limited role. So
Right, so it was around the...
it was around the levy, and we also had some discussions just around the previous law and justice recommendations that have been out.
And you were present at this meeting?
I was. Yes.
And with respect to Safe Work New South Wales, what did they identify as important issues,
So
as best you recall?
So a lot of the conversation that we would have had would have been around the work that they've been doing to date and the new legislation that has come into effect for them and how they regulate.
And iCare, what did they have to say,
So
as best you
again,
recall?
primarily about how they're managing the scheme, and that ultimately the scheme is being managed quite well from the terms of, you know, it's funded, there are few complaints and they're dealt with quite well. It's done in-house, so we're having lots of conversations about some of the lessons in that. But we also did, you know, talk about some of the issues around younger people, and that being an issue for us all.
But just to confirm, and I'm not pleased reflecting on you personally, but the matter of silica dust exposure for tunnelling work wasn't on the agenda explicitly, and it perhaps was dealt with at a more implicit level where it was picked up and maybe discussed as you went back and forth on other issues. Is that?
Yeah, as
Yeah.
I understand it, I think it was. I'd have to check, but I do think it was listed as an other item in.
If you could do that, please,
Yep.
on notice, I'd like to know whether or not it was expressly
I could
listed.
probably come back to you quite quickly. I think.
Okay. Well, I'll allow you to do that. There might be some further questioning. I'm not sure from any of the members. Abigail, did you have any further questions? Bob Navarre, yes, Honourable Bob Navarre.
Just coming back to the issue of more data collection being of some utility to CIRA. As I understand, the state and national dust and respiratory registers require health authorities to notify of a diagnosis of a patient if they have a particular dust disease or respiratory illness, but not necessarily if a worker has been exposed to dust levels that are above a workplace exposure standard. Do you have a view as to whether or not that exposure data should also be collected to assist organisations like CERA and iCare with respect to, you know, modelling and projecting potential exposure down the track?
As I said, the more data that we have, the better that we're able to, you know, do predictive modelling and understand the issues that may come up. So I think it would be helpful.
Particularly with respect to the exposure of the scheme
Yes,
to
particularly with respect to
liability down the
exposure.
track.
Thank you. I'll finish on this last one. And once again, thank you for submission. Just on page 4 of your submission, 2.3 about CERA-funded support programs. Explicitly, it was referring to workers' compensation scheme regulator. Then it drops down to the dot points in the final paragraph about the $5.3 million in funding. I take it that's $5.3 million, but that's not for the dust diseases scheme. That's for the overall workers' compensation. Just on notice, I'm wondering if it is possible, and it may not be, but please try anyway, to disaggregate that 5.3 million and see if there's a specific amount which was sort of allocated for programs and works, etc., inside the dust diseases area specifically.
So I'll take it on notice to confirm, but they would not have been, because we don't have the legislative ability to fund dust and diseases specifically. So they would all be broader workers' compensation vocational programs that we would fund, and iCare would fund any dust and diseases specifically.
So without being cute about it, none of that $5.3 million would have gone into dust diseases.
No, would be my answer, but I will just confirm that.
Okay, that's fine. Thank you very much. If there's no further questions, thank you very much. Thank you for the work you've done in your first 6 months. I hope we didn't give you too much of a hard time. If we didn't, you should tell us. We'll give you a more hard time next time you come back. But thanks very much. You took some questions on notice, so thank you very much for that. Very grateful. And I suspect following the opportunity to read hands, excuse me, members may have some supplementary questions which will roll up to you. So once again, thank you, and thank you for the good work you do. Thank you.
Great, thank you.
Now, we've pulled up a little bit short of the allocated time, which leaves us a 15-minute gap before we have the next witnesses. So perhaps if we pause at this point and allow members to perhaps do some other things they may need to do, and we'll be back at 12:15 for the last 45 minutes. Thank you. And I'll thank our in advance our witnesses before us now for the next and final session, which will take us through to the end of the day for this particular hearing day. Representatives from Transport for New South Wales, Ms Drover and Mr Mullins. What we'll need to do first up is to have you either sworn or affirmed for the presenting of your evidence. So if we start with Mr Mullins, just simply full name, the role within the organisation, and swear either an oath or an affirmation, whichever you prefer, the words of which you should have in front of you. So we'll start with you, Mr Mullins.
Thank you. So my name's David Mullins. I am the Director of Work Health and Safety, Eastern Harbour for Transport for New South Wales. And I swear by Almighty God that I will well and truly interpret the evidence that will be given.
I think not your fault. I think there's various oaths. I do apologise. That's not your fault. We got the
Different oath. Okay.
So it should be similar, but so I think that you've been provided with what's the, dare I say, the standard one. Is that how do I get out of this? We've provided you with the wrong oath, but you've got the correct one now?
Certainly.
Okay. Please proceed.
So I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr Mullins. Ms Rowe.
Camilla Drover, Deputy Secretary for Infrastructure Projects and Engineering at Transport for New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence about to be given by me should be the truth, the whole truth and nothing but the truth.
Thank you very much. As we were discussing just informally before we came back after the short break, thank you both for coming along. As I said, that as we progress through our witnesses at the previous hearing and other exchanges and discussions we're having on, we came to a realisation that we probably did need to hear from the tunnelling experts, so to speak, from the point of view of the state, that is the New South Wales government and the department and the agency and the work that it does, to give us that sense, particularly in regards to tunnelling techniques. I'm not sure, beyond that general explanation given to yourselves about our interest, about what you can provide us to help us understand the matter, I can give you a more elaborate explanation of what else we're looking for, but certainly an explanation about tunnelling, the machinery used and related matters would be a great start. We then have members from government, crossbench and opposition, and if you're agreeable, after, if you wish to do so, making an opening statement, we'll share questions back and forth to elucidate on some of the points you've made and take us through till about 1 o'clock, if that's agreeable. So okay?
That sounds good.
Okay.
So we have got a bit of an opening statement. It's
that
very
would be
short.
Lovely.
And then very happy to talk to different tunnelling methodologies if that's of use.
That would be
and then very happy to answer any questions you've got.
Thank you, Mr. Roberts.
Okay. So look, we appreciate being invited here today. As I said, I'm the Deputy Secretary of Infrastructure Projects and Engineering. So we deliver a diverse range of public transport, road projects, rail fleet, active transport and property development projects across New South Wales. And Dr. David Mullins, a colleague here with me, he is, as he said, the Director of Health and Safety for the Eastern Harbour region. And he is part of the Safety Policy, Environment and Regulation Division of Transport for New South Wales. So we're actually from separate divisions, but we work very closely together.
Sorry, Doctor, I didn't recognise the...
Sorry,
doctor.
that's not, that's just correct.
Apologise.
It's not
The
Doctor.
title. No.
That's,
Sorry,
Mr.
please.
Oh, it is Mr. It is Mr.
No, I want to recognise it correctly, so thank you. Yep. No.
And David leads a team of health and safety professionals. He supports project delivery, but also road maintenance activities, transport operations, and that portfolio does include major road tunnel projects. We just want to state that safety of our own people, but also our contractors' workforces, is our first priority. There's no point delivering these projects unless they're done in a safe manner. And we do understand that dust, including silica dust, is a major hazard for workers and can lead to serious and potentially fatal lung diseases, including silicosis. We do acknowledge that some of our work on our tunnelling projects has the potential to expose workers to respirable crystalline silica. But this exposure is not necessarily just limited to tunnelling activities. It can also occur through laboratory, surveying and geotechnical activities as well. Our principal contractors for our work on a construction project, they are responsible for the safety and health management and control of the workplace, so the construction site. But we do require our principal contractors to have accredited safety management systems, as well as adequate resourcing to manage the health and safety risks commensurate with the scope of works they're delivering. The principal contractors must abide by the work health and safety laws to eliminate or minimise the risks of crystalline silica exposure so far as it is reasonably practicable, and to have a federally accredited safety management system. Transport manages risks associated with silica exposure for our own direct employees through the standards, procedures and guidance within our Safer Together safety management system. And we recognise the seriousness of exceedances on worker safety. For our major construction projects, the principal contractor is responsible and accountable for actioning any identified exceedances, but we do obviously oversight that process. Since the 1st of September this year, there is a legal requirement for both controlled and uncontrolled exceedances to be notified to Safe Work New South Wales. If there are any exceedances, they're addressed immediately with actions and requirements implemented to ensure the risk is being managed and adequate controls are in place to prevent any reoccurrence. Actions are recorded in the principal contractor's safety information system and/or Transport for New South Wales own systems. For our own employees, Transport also has its own occupational hygiene team that undertakes health risk assessments that anticipate, identify and assess the risk of workplace health hazards, including silica, and assist with reviewing and improving controls. More broadly, Transport also supports its principal contractors to consider opportunities to further safety improvements, such as through contractor workshops and the adoption of innovation and innovative trials, many of which are underway on the Western Harbour tunnelling project, including a world first trial of what we call a tele-remote or remote-controlled road header. I'm happy to talk to that a little bit more. So we thank you for the opportunity and very happy to answer any questions.
Thank you very much. Now, just before we open up for questions, perhaps if I just go directly to the primary reason that we thought it would be valuable to have you both to come here, to give us an explanation in layperson's terms as best possible about equipment, machinery and technology used presently, and perhaps looking forward as well, you've already foreshadowed this, for tunnelling work with respect to infrastructure projects here in New South Wales, in its general terms.
Okay, look, I might just start with a little bit of history.
Please.
So there are many motorway tunnels in Sydney. All of them were mined or tunnelled with road header technology. The only exception to that is the Sydney Harbour Tunnel, where for the harbour crossing underneath the harbour, they used immersed tube tunnel technology. So road headers are generally what we use, and I'll explain why in a minute. And they're an evolution of mining technology. So they're individual pieces of equipment, and they have a cutting arm on them, and they cut through the rock. They're particularly applicable in Sydney sandstone, which is a relatively soft rock. So road header technology works very well. We have one project at Coffs Harbour where we're using drill and blast technology and not road headers, and that's because the rock up there is very, very hard. So it's not Sydney sandstone. They're very short tunnels at the Coffs Harbour bypass. There's only 3 of them. One of them's only 160 metres long, so under European guidelines it's actually not considered a tunnel, but we're using drill and blast technology. So we drill a hole into the rock, we put in the blast, and then it is detonated. There's obviously no workers in the tunnel when that occurs, and there is a significant period of time after the blast where the dust settles and the material that has been blasted settles, and when a threshold is reached, workers are allowed back into that tunnel after the blast. But if I can return to road headers and why we use them. And I might do a little bit of a comparison with the tunnel boring machines, which are more applicable and used in the metro tunnelling space.
Thank you.
So road headers are individual units of machinery, and therefore they're quite nimble and agile. And that's important because for a road tunnel, we have a semicircle profile. And road tunnels are generally much wider in diameter than, say, a metro tunnel. So metro tunnel is round and usually small diameter, and that's why the tunnel boring machine is appropriate. In a metro tunnel too, you tend to have long, straight sections where you have very even profile. So you can set up a tunnel boring machine and they cut a circle, homogeneous circle for a long stretch of length. So that's appropriate. But in a road tunnel environment, you've got a semicircle profile. So if you were to use a tunnel boring machine, you'd have to cut twice as much area, and then half of it would be not required, and you'd have to backfill it, and you'd also end up with twice as much spoil than you need.
Yes.
So you'd be cutting twice as much volume, and you don't need to. And also, it's only been in recent times that tunnel boring machine technology has been able to provide a tunnel boring machine of the right diameter to actually cut the diameter we need. So, for example, the Western Harbour Tunnel is 3 lanes wide in each direction. That's a very, very large diameter of tunnel boring machine that is required. Now, we are actually going to use a tunnel boring machine to tunnel part of the Western Harbour Tunnel, and that's the bit underneath the harbour, and that's because of the geology under the harbour. But we primarily use the road headers. One, because they're nimble and agile, and that's another feature of motorway tunnels. You have many more changes of lane. So you often in 3 lanes, it goes down to 2. It might come up to 3 again because you've got an on and off ramp, and there's more on and off ramps. So you've got a much more uneven profile in a road, and that's why you need the agility of a road header machine to cut that uneven geometry. So that's why we don't use a TBM. Plus the diameter. So the diameter of the tunnel boring machine that we're going to use on Western Harbour Tunnel will be the largest ever in the Southern Hemisphere. So it hasn't been around at that diameter for very long. Also, it's good to cut through fairly soft Sydney sandstone. So there's some rationales as to why we use road headers. And as I said earlier, road headers have been used on every motorway tunnel in Sydney since they were first built. And even Metro will be using road header technology to cut their cross passages. So where they haven't got a long contiguous profile, circular profile, they'll be using road headers to cut in other areas. In terms of what it means for the worker, so there is a cutting face, which the road head is obviously cutting. That does generate dust through the cutting process. So there are control measures in place to manage the dust that is generated at that cutting face. The primary measure and the engineering control is ventilation systems. So there are mechanical ventilation systems that suck the dust from the cutting face. It takes it through a whole series of cleaning mechanisms. The scrubbers, they're colloquially called, and that cleans the air and takes it also away from the cutting face. So that's one of the measures. There's also dust suppression systems, including wetting systems, that if there is any dust in the air, water's applied to it and it obviously settles to the ground. The other control is the fact that the worker controlling the road header is actually within a sealed cab. That cab is sealed, it's pressurised, and there's also filters in that cab. And they're the HEPA filters, so high degree of filtration. And that keeps the cab enclosed, but also if air gets into it, and it obviously does as the worker gets in and out of the road header cab, the air is also cleaned. Over and above that, the worker is also wearing a mask. And in recent years, P2 masks, of course, were mandatory. In more recent years, the technology has improved, and we're now using VersaFlow masks. So they are a full face mask. It also means that workers that are not clean shaven can wear this mask. It also provides eye protection. It acts somewhat as a hard hat as well. It's fully enclosed, and the air is filtered that they're breathing in as well. So there's a whole level of controls in place to make sure that the air that is going into that worker's lungs is managed and controlled and mitigates the risk of silica. And then, of course, over and above that, there's monitoring and reporting of the ambient air quality in the tunnel at the same time. If there are any exceedances of the standard, and we don't set the standard, that is set at a national level, those exceedances are reported, and they're reported whether it's a controlled exceedance or an uncontrolled exceedance. So a controlled exceedance is where the ambient air quality has breached the threshold, but the other control measures, including the worker being inside the cab and wearing the appropriate mask, has managed that situation. So it's still an exceedance, but there are sufficient controls in place to make sure that the air getting into the worker's lung is not subject to that background air. And then uncontrolled is generally where there's been a breach of one of those controls. The most common example of those breaches is where the worker has taken off their mask, and that is classified as a breach and an uncontrolled exceedance, or whether they have had an incorrectly fitting mask. And that is still reported and managed. So that's why we use road headers. If I can just talk about some of the innovations that we're trialling on Western Harbour Tunnel.
Yeah, please do.
So one of them was actually initiated by one of the road header workers. And it sounds straightforward, but actually it's an important control. There is now a boot wash. So as workers get in outside the cab, we want to keep all the dust and including silica outside. So they now wash their boots before they get into the cab, so they're not taking any particles into the cab. So that's something that we're trialling on Western Harbour Tunnel. The most innovative and, as I said, world first is actually using a tele-remote road header. So at the moment we've got one of these working on Western Harbour Tunnel. It's controlled by a worker 200 metres away from the cutting face in a sealed shipping container. It is still at the moment underground, but they're a long way away from where the dust is being generated, and they're controlling that road header. And with time, we're actually hoping that that can actually occur with the worker being on the surface. So the worker won't even be in the tunnel. They'll be controlling the road header from a surface location, and therefore well away from the dust. The other initiative that we're trialling on the Western Harbour Tunnel is, it's called Jet Black, and it's a room that the worker goes into, and through extraction of dust from their clothes and their hair and their body. So again, they're not taking away, home or into their car, any of that dust, including silica. So there's a whole range of measures that we continue to trial. We've had a couple of workshops with our contractors in the tunnelling space in the last year, looking at are there other things we can do to improve worker safety, more broadly in tunnelling generally, so not just to do with silica, but one of the focus areas was the management of dust and silica. So we continue to innovate, and as I said earlier, the VersaFlow technology is only been introduced in recent years, so it's being applied on the M6 Stage 1 and Western Harbour Tunnel. It was just a few years ago that the P2 masks were the only mask available, that they are still satisfactory and they provide a good level of protection, but the VersaFlow is an improvement on that. And particularly those that don't want to be clean shaven. They can work safely with a properly fitting mask. Those masks are custom fitted to each worker in the VersaFlow instance. And even with a P2 mask, a lot of attention and focus is on education on how to wear a mask appropriately. And there's good surveillance on ensuring that workers are wearing them appropriately, because that ensures their efficacy.
Well, Mr. Judge, that's very helpful and very useful background information. Before I open up for questions, Dr. Myers, do you want to add to any of that? It's been obviously very comprehensive, but any additional information you'd like to just put on the table before we open up for questions?
I suppose the key content put forward by Camilla has been around some of the innovations, but beyond that we have a number of the standard, if you will, safety controls around OFSC accreditation. So when we engage a partner, a contractor to perform tunnelling works, we're looking for a very high standard of safety management systems. So we go through a fairly rigorous procurement process with those contractors, making sure they have got the capability to be able to perform the work safely, that they have the depth of knowledge, the skill sets that we need to be able to perform the tunnelling in a safe fashion. And beyond that, the general health risk assessment process, where they go through a pre-assessment, safety and design assessment, where you look at all the components of the tunnelling activity, the construction activity, and seek out those hazards that could present as a result of the tunnelling operation, both silica and beyond. Obviously, with tunnelling, there are quite a number of potential hazards that need to be addressed. But obviously with a keen focus on silica as probably the number one key issue that we need to manage consistently across all the tunnelling works in all locations. Thank you.
No, thank you. That's very helpful. Abigail Boyd.
Thank you, and good afternoon, and thank you for coming to answer our questions. I just wanted to talk about, Ms. Drover, you talked about the controlled exceedance versus uncontrolled exceedance. How does that fit in with, my understanding is that the monitoring that's done already applies a discount according to what the worker was wearing, but there is still, obviously there can be exceedances despite what the worker is wearing in terms of respiratory protection. Does that fit within this kind of uncontrolled exceedance that you talk about?
Okay, I think there's two types of measurement done.
Mm-hmm.
There's one on the ambient air quality within the tunnel environment, and there are exceedances that can't be breached in that regard. Then there's also another measurement, and David can help me out here, that applies to specific workers.
Mm-hmm.
So there is a requirement, and it's a threshold based on the duration of exposure. So it's a weighted time level. And so that is calculated for individual workers.
Yeah.
Do you want to perhaps explain that a little bit?
Yeah, so I suppose the controlled and uncontrolled is, I suppose, a clarification point as to whether or not the last line of defence, the PPE, is being effective or not. So whilst you have the personal monitoring and you have the background monitoring, if you have an exceedance, that doesn't necessarily translate to a direct inhalation of dust if the person is wearing, for example, a VersaFlow pressurised mask.
Correctly, and has worn it correctly the
Correct.
entire time and not taken it off for any reason, etc., etc.
Yeah, and they remain within the cab, which is sealed. So the ambient air quality in the tunnel may have breached the exceedance. We hope it doesn't, but if it had, if they're within that cab, which is pressurised and sealed, and they're wearing their VersaFlow, the impact to them should be negligible. So it's still an exceedance because the background air quality shouldn't have, been at that level.
Yep.
But because of the control measures are in place, the impact to the worker means that exceedance is negated.
So the Australian, So the Australian Workers Union, I'm not sure if you've read their submission or you're familiar with it, but they had tried to get air quality data out of Contractors were unable to, they got it out of, they were trying to get it out of Safe Work as well, unable to, they got it out of Transport for New South Wales in relation to certain projects. And in relation to the Metro tunnel project air monitoring data they received, there was a huge number of exceedances that had been reported under those contracts. My understanding is that under an ordinary contract for this sort of thing, so something like the Western Harbour Tunnel, you would have a provision in there that said the contractor needed to immediately notify if there was a work health safety issue.
That's right, and they do.
So does that mean that you also have all of this data on exceedances from the contractors in relation to all of these projects?
We have a lot of data. I think one of the challenges we've had is if the data isn't ours, so it's contractor data, we have no issue with sharing it, but we need to seek the approval of the owner of that data before we release it, because it's not our data.
Yeah.
And I think that's caused some problems, as I understand it. So if we have the data but it's not ours, we're happy to share it, but it's subject to, you know, the consent of the owner of the data.
So in relation to the exceedances you've received notice of, what do you then do in relation to that?
Oh, I might give you the...
Sure.
Dave.
So we have embedded safety partners within each of the project teams from Transport for New South Wales employees. Those safety professionals work very closely with the project teams and obviously their safety teams and the occupational hygienists. So the exceedance data or the air quality monitoring data is discussed weekly or monthly, depending on the meeting cadence for the project, and that's also posted at the entry of all of the projects for the workers as well. So it's fairly transparent. The data is provided to the workers, and it's also provided in reports to us. We don't necessarily compel the contractor to provide us the monitoring data, so we don't collect or harvest data, but we do go through exceedance and expect that we're notified of any exceedance, and then we work through a process of corrective action. We work through what caused the exceedance, what were the control measures that were in place at the time, and what are the potential improvements that can be put in place.
So when you say the data is available for workers, it's posted up, is that just in theory, or have you seen that yourself?
I've seen that myself.
Okay, because we had a lot of evidence that workers were unable to obtain this data themselves, and that it wasn't something that was being posted up, or that was, and that's why, I mean, the very fact of having, a GIPA request for the information shows that it was not able to be obtained readily. Does that concern you? Does that not accord with your understanding of all of these? You say you've seen it. Have you seen it in all locations, or?
I can't say that I've seen it in all locations, but what I can say is that depending on the interpretation of the data, so the raw numbers are often published on safety notice boards. Interpreting that data, being able to apply that may be a question that workers have further. I can't really speak to how the contractors manage that, but I know that the data is available, and certainly to us as Transport, if we request details of the activities being undertaken, that's provided through reporting.
So, and am I right, David, if there is an uncontrolled exceedance, so potentially there is actually an impact on the worker, we do log that in our own safety management system and we report on it. In that instance, I would get notification of it.
Okay, and do you then tell Safe Work?
It may have already
It's the responsibility of the PCBU, which is the principal contractor, to make that notification. So we don't personally notify Safe Work in those situations.
But you don't check to make sure that they have?
No, there isn't a feedback loop that comes back to us, so we don't get anything from Safe Work.
So at what point does Transport get involved to say, actually, come on, there's a risk to workers here. There's been a lot of exceedances. This keeps happening year after year, month after month. So At what point do you? I hear what you're saying about having, sending in your own safety person, etc. It's not the same as having an external regulator coming and actually inspecting and looking at it. At what point do you sort of take that responsibility to make that sort of notification?
So I think we are getting the data, and our safety professionals are reviewing the data. And look, the way it operates is, if there are incidences, safety incidents, particularly on a site, people, including ourselves, generally know about it. And I know myself, I'm often told, oh, yeah, safe work has been notified. So there is that sort of, there's that culture of checking, okay, something's occurred, has it been reported in the correct place, and have the relevant regulating parties like Safe Work being notified.
We've received significant evidence to this inquiry, including at our hearing the other day, where we've heard of workers not being adequately protected, it not being feasible in the circumstances to work long shifts with masks on the entire time in all circumstances. We've heard of employers not sharing data readily. We've heard of a real sort of picture, very sort of, it's a bit ironic, but it's not really a clear picture, but a very polluted picture of what workers are experiencing in these tunnels. Doesn't seem to accord with what you're saying to us here, but you do have the power under those contracts to ensure that these contractors are doing the right thing. Given the evidence we've received, is there more action that you think you can take under these contracts to ensure that these work health and safety standards are being met?
Well, I think one of the examples we did do, as I said earlier, we've held these workshops with all our contracting parties in a non-compete zone. So they all come together, and the focus was on how can we improve overall safety in the tunnelling environment. As we again said earlier, it wasn't just about silica. There's obviously, there's an interface between individuals, personnel and plant. That's a key risk in a tunnel. There's obviously electrical risks, etc. But on the silica case, they did come together with a committed effort to see what can we do better to improve the outcomes for workers. And I think the evidence of those innovations that are being trialled, particularly on the Western Harbour Tunnel, but even the introduction of VersaFlow on the M6, on the prior projects, that they weren't offered to workers, in part because the technology wasn't there. But now that they are offered to all workers, they are custom fitted to that individual worker. So I think, as we go forward, there are always opportunities for improved technology adoption and that ongoing review of are there better controls that we can put in place.
Just a quick
Can I do the
final
question on your Roberts?
Sorry.
I think
No, that's
shout
right. I was
round.
just going to ask one.
Okay, we'll jump in. Yep, go on.
Yeah. So,
Who's going?
Yeah.
If you've got
it's
one.
very small.
Go.
I just wanted to check, is there a potential for financial penalties on the contractor if they do continue to breach work health safety standards?
Well, if they breach their accreditation, they can't work at all.
I mean under the contract.
We do performance scores of contractors. We're looking at a range of measures. One of them is safety. So if they get a low score, it may be behaviour or safety and a range of other things, it will impact their ability to work with us again. So there are secondary impacts, but there are more direct consequences. If they've breached an exceedance, it has to be reported and addressed, work safe, and if it's obviously serious, then their accreditation is breached and they cannot tunnel.
Sorry.
Thank you, Chair. Just two quick questions. And first of all, thank you very much for attending today, and in particular, your evidence, Ms. Drover, in terms of road header machines versus tunnel boring machines. I have absolutely no idea. I don't think I have much more of an idea, but I have a little bit more now, thanks to you. Because we heard evidence that the tunnel boring machine, in fact, is probably safer from a worker's viewpoint in terms of dust extraction, distance from the actual cutting place, etc. But you've cleared a lot of that up. Just quickly, two things. You said along the lines of the data you receive from the principal contractor, you can't, let's say the word air, because you don't own the data. Something along those lines. It's hard to adjust a contract once it's already been written, but going forward, is there the potential to have in the contracts, or although the principal contractor records the data and it's their data, that it can be and should be shared by you if you desire?
Look, happy to take that away and have a look
Sure.
at it. Look, I would hope that contractors are sharing data with their workforces. I think we've got some evidence that they are, and entry to site is a good location. But if there's more that we can do in that space, very happy to take that away and have a look at it.
And we raise that because we've received evidence here, sworn testimony from people saying that they can't get access to that data.
Yeah.
So data's powerful, as we know. Information is powerful. So we're looking to be able to provide the worker with that access to that information. And my one and only other question, Chair, is we know it's the role of the PCBU to provide that information on overexposures to safe work. It's their role. They also notify you. Perhaps you could look at it and take this away again and come back on notice with you being a mandatory reporter of that information to safe work. So we ensure that it's there. As you say, I think it might have been Dr. Malone said there's no feedback loop. We're entrusting the principal contractor to provide that to safe work. Well, if they're already providing it to you, can't we just ensure that it's forwarded on by your organisation and therefore we're safe in the knowledge that safe work has been informed?
Yeah, look, I wouldn't want to cut across the obligations and responsibilities of Safe Work, and they're obviously an independent party. That is their role, to regulate what happens in terms of safety on sites. But I think there's more informal processes. As I said earlier, if there's an incident on site, many of us are checking that WorkSafe have been notified, and of course we're all doing our own assessments, investigations about what occurred, and particularly if there's something that we can do immediately that will address the issue.
Well,
that's just the nature of the behaviour and culture on site.
Most certainly, and I understand that. And I'm not asking you to cross over into Safe Works patch. What I'm suggesting is I have great fears, and I've spoken about it personally and publicly and aired it here before, of the ability to Safe Work to actually regulate. So what I'm suggesting is if you are mandatorily notified by the principal contractor, that perhaps you should just provide it to Safe Work and then we know that they've got it. It's just one more email further down the line. So that's something I don't expect you to comment on it now, but take that away and come back to us if you think that that's just a simple, reasonable proposition.
Chair, could I? Is that okay?
Yeah.
No, you go first.
No, yours might be related. Is it related to that?
Yeah, pretty much.
Yeah.
Yeah. So, in the earlier evidence, you mentioned that that not all the incidences were necessarily of overexposure or exposure were reported. You said there was a lot of data going on, but not necessarily everything is reported. Can you just elaborate on that a bit?
Okay, so all exceedances of the background air quality are reported. By the contractor. Yep, because that's their accountability and responsibility. They are responsible for the safety on that site. They're the principal contractor. However, because there is if it's uncontrolled, for example, the background air quality wasn't satisfactory and the worker took their mask off or left the door open of the cab or something, and therefore there was actual exposure to that worker, we log that in our safety management system.
And so the principal contractor would still have to record that, but you also log it.
Yes.
Right.
But if there's a ambient air quality exceedance, but the control measures in place were effective and there is no impact to the worker, then we don't include it in our safety management system. Okay. So although we're not the principal contractor, we actually do record safety incidences on sites.
And is that whole hierarchy of PCBU, is that by virtue of the regulation or the act whereby, essentially Transport for New South Wales has engaged a principal contractor and then, if you like, transferred the liability of reporting, or not transferred by virtue of, I'm just trying to understand the legislative framework, to them, is that how does that separation occur if Transport for New South Wales is essentially paying the money to get it done? I'm just trying to understand that disconnect.
Okay, so we contract a contractor,
Yeah.
a construction company, to deliver a project. And in that instance, they are the nominated principal contractor.
Yeah.
So they have overall accountability for the safety, the security of the site as well. So they control who comes into the site and who doesn't. They are responsible to ensure that that is a safe workplace at many, many levels, so that the design of their temporary works are safe, the design of their permanent works are safe, that the design of the environment in which those workers are working is safe.
The thought occurs to me that there perhaps is a little bit of a disconnect there between the person who's ultimately paying for the work, and there's potential conflict of interest there, whereas I'm just thinking in terms of legislative reform, if Transport for New South Wales were responsible for the collection and reporting, there's a potential elimination of conflict of interest there, because sounds to me like some of the evidence indicates that not all the data is available. And could you just elaborate for my benefit on the requirements upon the principal contractor to share the data with the employees? Is that a requirement that they must share it?
It's nothing specific in our contracts.
Right.
I would suggest it's probably just best practice to provide that information, be transparent with the employee groups.
And from a WHS point of view, regulation, legislation, there's no requirement for them to share that data?
There is a requirement to share any hazards in the workplace and then discuss those under a consultation process. So if there is a hazard identified through whatever measures, whether it's an inspection, testing and monitoring process, whether it be silica or other, to raise that and discuss that with the work group under their consultation arrangements. So whether it's a Work Health and Safety Committee or through a HSR or other mechanism that the...
So it's more a consultative rather than a mandatory. Sounds like things need to be tightened up there a bit.
I think there's some other controls that we probably should talk to. For example, at the start of every work shift, there's what we call a toolbox talk, or pre-start, where the works to be undertaken in that shift are stepped through, with particular focus on the safety requirements of that individual bit of work. There's also safe work method statements, so SWMs. So before you do anything, you actually have to have that safe work method statement. And again, all the workers are stepped through that before they start the work. And a part of that is what PPE you must be wearing and how you must be wearing that. So that happens before every bit of work is undertaken on a site.
Can I just one more thing before I hand over to my colleague? You mentioned the P2 use of P2 masks. Can you just reiterate or elaborate for me in what situations those P2 masks would be used?
So everyone must wear a P2 mask in a tunnel or a VersaFlow mask. So the problem with a P2 mask is you want a perfect seal between the skin and the mask.
We were always told in the electricity industry that I originally came from that they were a substandard use of PPE because you don't have the positive airflow and because of the seals not that great. So they were very much looked, for want of a better phrase, looked down on as a form of PPE for respiratory airborne particles.
Which is why our contractors have shifted to the VersaFlow. There are some workers, however, that...
But it's not mandatory to have the VersaFlow.
It was actually mandatory, is my understanding, on one of the projects, but there was a workforce preference for it not to be mandatory. There are some people that do want to maintain a beard, for example, and therefore, they have to wear VersaFlow. But there are a few others that preferred the P2 mask. So it is, as I understand, no longer mandatory, but there's a preference.
Okay, all right.
But they're certainly provided, and they are an improvement on the technology because it does mitigate some of that, that fitting wearing risk. Look, I know myself when I go underground, and if I'm in a bus, for example, I have to put my mask on as I get in the bus on the surface before I go down underground. And in my experience, there are always checks that everyone on that bus is wearing the mask correctly, because that is, part of the safety provision.
Okay, thanks.
Thank you, and thank you for coming. Have you had the opportunity to read the transcript from the previous hearing on the 29th of November?
Unfortunately, I haven't.
Okay, all right. So I think just on that, if I briefly summarise, proposed reforms was expand the disease coverage under the scheme, strengthen SafeWorks' regulatory role, and streamline air quality data access, ensure real-time publishing of safety data in workplaces, and promote inter-agency collaboration for prevention and treatment. And because we haven't got a lot of time, how is Transport for New South Wales preparing for potential legislative or regulatory changes regarding dust exposure or anything that was spoken about today?
Okay, well, there's a couple of things, and I will get David to help me out. But, I mean, we got new requirements on the 1st of September this year, so we obviously have supported their implementation, and we haven't had any issues, to my knowledge, of the implementation of those new requirements. But I think, there's obviously the regulation and procedure sort of dimension, but over and above that, as I said, we're doing our own initiatives with industry and not individual contractors, but with all our contractors in the tunnelling space to look at tunnelling safety. Now, we also work quite collaboratively on a number of issues with Metro where we can, where that's applicable, because if there's anything we can do to improve overall workplace safety, we will. So I think that's our commitment. I can't speak to what changes may, be recommended for WorkSafe, etc. But what I can say is we obviously support the transparency of information for workers.
So are there any... do you see any barriers that hinder the implementation of best practices in the prevention of dust diseases on your projects?
I think it would depend on the specific the measures in place. Obviously, as you mentioned, there was an IR, dimension to the VersaFlow. I think good intention was let's mandate it, but there was some feedback that perhaps wasn't, right for everyone. So it would just depend on what the measure is.
Yeah.
But I think that, the trials we're doing at the moment, they are trials. We want to look at the efficacy, and yes, absolutely, if they work, we'll be rolling it out more broadly. We've got one of those tele-remote road headers. But that would be a bit of a game changer if we've got workers tunnelling from the surface, down the track. There'll still be some workers, of course, in the tunnel.
Yeah.
But the road header operators that are operating for long shifts, the more we can do to support them and make it safe, that would be a benefit.
Okay. And how do you audit and enforce compliance with dust management protocols?
So I can talk to that. So we have a number of initiatives. Critical control monitoring is one of them. So we have teams that are actively undertaking surveillance within the tunnels. So that's on a daily, if not weekly, situation. We perform the critical controls monitoring through observation and validation of the monitoring reports. The reports that come back after interpretation from the lab and the occupational hygienist. And where there are exceedance, we sit down with the contractor and ask them to go through the requisite controls, their improvements, identifying what the failure point was, what the control failure might have been, and then work with them on what the resolution will be, so the non-conformance, and then close that out as a conformance. So a standard sort of a safety auditing, such investigative such auditing process. In addition to that, we sort of spend a lot of time trying to focus on what improvements we can, as Camilla mentioned, trying to seek any opportunities. So, for example, in Western Harbour Tunnel, it isn't the panacea, but it is an improvement in that they're using a handheld air monitoring device on each of their safety walks. So when they go for a safety walk, they'll grab a handheld device. Now it's obviously very low tech. It doesn't have the same oversight as an occupational hygienist and the review and process, but it is an indicative activity that provides another data point, and it provides us with an indicator, as opposed to some of the air quality monitoring situations take a number of days to return the details and take action. So this is a more tactical initiative that can be utilised to gather immediate information and give an indicator that there may be an issue or that the action needs to be taken.
Mm-hmm.
Just on our road projects too, we have sort of, if you like, two levels or different types of surveillance. So there's surveillance officers.
Mm-hmm.
They're wandering around, inspecting the works, looking at quality, but they often are looking at safety, and particularly safety risks. And it's very common for them to raise a concern. And then we have our safety partners as well on site.
Mm-hmm.
So they're coming at a pure safety perspective. But it's often those surveillance officers that are on site more often than not, that are inspecting all the works. They're seeing what's going on. They can see where there's non-compliance with PPE wearing. And that's our own team. Of course, the contractor has their own teams doing that as well.
And so when you're doing the audits, are you also like speaking or addressing worker concerns, and in doing that, are they investigated and resolved in that sort of working environment? Or, you know, like if they're saying to you that they want access to the air quality and in real time, how is that being addressed?
We don't have a direct relationship with the contractor's workforce because they're the employer, and they are responsible for safety outcomes on that site. Our role is more a review, supervision, sort of oversight role, as opposed to direct relationship with their workforce and their subcontractors' workforces. So on any construction project, a lot of the work is subcontracted, and then those subcontractors have their workforces.
Okay, so then they would report to their employer, and then the employer would hopefully pass on those concerns. How
I think there's probably a couple of activities that sort of bridge that gap, if you will. Our principal contractors will invite leadership walks. So, for example, it's not uncommon that we will attend site, we'll have a walk around the site, we'll show what's going on. It gives us the opportunity, more importantly than to observe, but to speak to workers, ask them about the situations that they're dealing with, what their safety hazards and risks are, and that's a fairly common on all of our projects to undertake that. So that's provides us insights and opportunities, and then we'll take those back. We generally won't make direct comment to workforce, but we'll certainly have those discussions with the principal and opportunities to improve from there.
Mm-hmm. And then just one final question. You were talking about the toolbox talks that you do in the morning. So is that where, and you said about the PPE usage, is that where you would be looking at that they're ensuring that they fit, all of those kind of things? Or
so those pre-starts toolbox talks are undertaken by the contractor, because they're supervising the work and with their workforce or subcontractors. But it's not uncommon for us to attend those, particularly if there's a particularly special bit of work going on. Transport for New South Wales Resources attend, and if we are part of those works in any way, we have to attend that pre-start as well.
Okay.
The only thing I would add is that whilst the toolbox talk is very tactical about the day's work and the activities of the moment, in addition to that, all of the contractors do undertake additional training, which isn't necessarily related to the toolbox, around mask fit testing and how you actually wear your mask correctly, and any technicalities, particularly with VersaFlow, how they're utilised and so forth.
Yeah, okay. All right, thank you.
We've gone over time, but I'm wondering if you'd be generous enough to just provide a few more minutes. Bob Nambar's got a question that he'd like to bowl up.
Thanks. Thank you, Chair. Look, there's been a significant body of infrastructure work that's taken place, particularly tunnelling, in the last decade, certainly since 2014. just wondering, have there been examples where contracts have not been awarded to bidders on the basis of non-compliance in a safety sense or exceedances, where those things have been a contributing factor to not awarding a contract?
Not to my knowledge. Because of the tunnel environment, and it's not just because of dust in the tunnel environment, they are highly managed, regulated environments. So we actually often get a better safety outcome overall because it is so managed. So if I look at the statistics for road maintenance, for example, compared to a tunnelling environment, statistically, it's actually a safer place, just because it's a very controlled environment. But in terms of procurement, it's a small market of tunnellers in Australia. They are the tier 1 players. There's quite a few overseas participants that have been attracted to this market because of the amount of tunnelling work. They are specialists. You don't get any, construction contractor operating in the tunnelling space because of the speciality required, but also the accreditation requirement. As David said, it's actually quite tough to get that tunnelling accreditation, and we haven't seen significant major safety issues of late.
So I suppose I'm interested just in terms of what would be informing that outcome where, contracts have not been, there haven't been instances where contracts haven't been awarded on the basis of non-compliance and exceedances. So what would be informing that is more the fact that there aren't those issues of non-compliance and exceedances that would be of concern to Transport, or that there just isn't enough of a pool of contractors to award these jobs to, which would necessitate just...
it's not because of safety issues because I think, as I said, overall the safety outcomes on tunnelling projects have, there's always some anomalies, and there definitely have been exceedances of air quality. There's been other issues, injured workers, etc.
But the control measures have been adequate where there have been exceedances?
Or where issues have occurred, they have been investigated and addressed, and if they're obviously of any severity, including by Safe Work New South Wales. But I'm not aware of any contracts, because that there's an EOI process, so before you even get the right to tender, you've got to be pre-qualified and you've got to have the necessary accreditations, and they're a function of your capability but also your past work. And even in the procurement phase, part of your tender submission is a whole lot of safety management systems and a whole lot of other plans which explain how you're going to do the works safely. And the sub-plans below that. There would be a silica management plan. There'd be a plan of how you're going to manage other particulates. So, for example, road headers, getting back to road headers, are electric because we don't want diesel particulates, in tunnels if we can have electric equipment. So there's a whole lot of checks and balances and measures before a contract is awarded.
The data that Transport collects during the construction phase, when it's reported to you, presumably that forms part of your assessment during the procurement phase for any future infrastructure
If we had
projects.
concerns about any contractor, tunnelling or otherwise, if we felt that they had an unsafe culture and certainly unsafe outcomes, we wouldn't pre-qualify them, we wouldn't shortlist them for projects.
Do you
and
share...
we do look at that, and that's why we do those contractor performance scores. Part of that is assessing are the behaviours right, is their safety outcome right, appropriate, are they easy to deal with, are there commercial matters, and that goes into our assessment of their appropriateness to work with us.
The infrastructure boom over the last decade hasn't just been confined to New South Wales. Certainly Victoria, Queensland have had many similar infrastructure projects. Do you share, I suppose, intelligence with your other state-based counterparts with respect to the safety records non-compliances, exceedances that may have taken place in those jurisdictions as well?
Not so much data and exceedances with other jurisdictions. One of the things we have done, which actually came out of the Legacy RMS organisation, is the SAFER initiative. So this has been running for quite some years, and David can help me out here, but basically we've taken all the safety data from all our contractors, and it's well beyond silica, of course, but so they're TRIFRs and LTIFRs, and we actually put that into a reporting mechanism, and we share that with industry. Now, it was de-identified data. I think it's now identified.
Yes, it is identified.
Yeah. So they can see each other's safety performance. Now that to me shows a degree of maturity, the fact that they are willing to share with their competitors, and therefore, and the fact that we're facilitating that demonstrates that we value good safety outcomes. It also means that we can see if there are particular issues in industry. So probably our highest risk on construction projects in terms of safety is the conflict between people and plant. That generates, a high degree of incidences, or a high number of incidences, and therefore the programs that we will focus on and the programs they will focus on will be targeted towards that. Another area of concern is workers in live traffic environments. So we've been doing a lot of work with industry and contractors to address that particular issue. So there's an example of, for transport projects, we're aggregating all that contractor data, sharing it, being very transparent, and then with that body of data, looking at, well, where are we going to target to address ongoing safety risks. And then we meet with the contractors. In fact, the forum was about, 6 weeks ago?
It was, yeah.
Yeah, where they all come in, we look at that data as an industry, we share those lessons learned, and then out of that generates initiatives for the next period of time.
Is that data accessible publicly, or is it just...
I don't think it's shared broadly, other than with the providers of the data.
Right.
But as Camilla mentioned, we present that data to the industry forum and discuss, opportunities for improvement. We also have experts in to, talk about subjects such as silica, to provide broad understanding, bring minds together, and contemplate, next steps as far as improvement across industry at a fairly strategic level, obviously. But what those executives also bring is not just transport intellectual property, but their broader operations. So the larger contractors obviously work both in Australia and overseas, and they bring that wealth of information to those forums and share some of the improvements and opportunities there. And that's where some of the Western Harbour Tunnel initiatives have really come to the fore.
We also see the benefit in, it's often the tier one contractors, the larger contractors that have the resources to trial, new methods or new equipment, new technology. But if we can share that with the lower tier contractors, the smaller ones, that's educating and bringing the whole industry up. So that's the other purpose of sharing that information, and particularly around traffic control. There's been some recent innovations in that space that we are wanting to roll out more broadly.
Okay. Thank you very much. Well, thank you for being very generous to take those additional questions. It's much appreciated. I found this session very, very interesting. Had my time around, we would have got you in, I think, first up to give us that very contextual, broad information about tunnelling work. So thank you very much for that. Now, I think there might be some questions on notice, I'm not sure, but I expect there might be some supplementary questions that would arise from members having a chance to read hands up once it becomes available. So if there is, the Secretary will liaise with you. So on behalf of the committee, thank you very much, and have a good afternoon. Thank you.
Thank you.
Thank you.